Lordship, I would like to mention item number 1
Why?
for adjournment for today, and matter may be listed after tomorrow. Matter may be listed tomorrow.
After
Lordship.
tomorrow.
Not after tomorrow. Tomorrow. Matter may be listed tomorrow.
What's your
Lordship.
name?
T. Kyamdo.
Huh?
Pardon.
What's your name?
T. Kyamdo, sir.
Mr. So-and-so. You are there. You are not there. Your name is there. Have you signed the Wakalatnama?
Yes, Lordship. Actually, my senior counsel is could not make today to court because
Item 1.
Yes, Your Lordship, item number 1.
Motion
Yes, motion.
on the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. Kalin Dukam Vigya,
Yes. Your Lordship.
learned counsel with the petitioner. List this matter on 31 8 2023.
Chopaj.
May I, Lordship?
Yes.
Lordship, I like to mention item number 12 and 13 on behalf of T. Tapak.
Huh?
On behalf of T. Tapak,
Okay.
he is under medical treatment.
Your name?
B. Sivo.
Mr. B. Simo, learned counsel appearing on behalf of Mr. Tabit Tapal, learned counsel with the appellant. President. Matter may be listed after
3 weeks.
3 weeks. Praise the Lord. List after 3 weeks.
Be please, Lordship.
Yes,
I beg to mention, my lord, item number 14.
14.
So yeah, it's a supplementary hearing. I could not prepare well, my lord, due to my eye problem. So 2 weeks
Okay.
time may be granted, my lord.
What is your eye problem?
So because I was suffering from mild stroke, so
Okay.
ear and eye problem is still on, my lord. I'm under treatment of Apollo Hospital.
Take care. Take care. That's very risky.
My lord, 2 weeks time.
Mr. You take a learned counsel for the appellant. Press for and granted 2 weeks time. List this matter after 2 weeks. Item
Okay.
14, correct?
Yes,
Item
my-
14.
My lord.
May I please open? I'd like to mention an unlisted item. It's a AB, kindly it may be taken up today.
We'll see.
Obliged.
May I, my lord?
Yes,
My lord, I beg to mention item number 26, my lord.
26.
Yes, I am for the respondent, my lord, on behalf of OPATA.
No, you have mentioned it yesterday, so we fix it today.
Yes.
What's wrong with Opada?
My lord, so sorry, senior is out of station and I'm not got proper instruction from my senior, my lord. Kindly matter may be listed after 2 weeks, my lord.
Learned counsel, you must first, before making any mention before the court, you must take proper instruction. Unnecessary. On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. Ozingpada, learned counsel for the respondent number.
Respondent number, sole respondent number,
Huh?
sole respondent, my lord.
Sole respondent. Sole respondent. Again, prayed for listing the matter as the matter has been listed on the prayer of the learned counsel the other day. List this matter after
After a week, your
7
lordship.
weeks.
After a week, your lordship.
Huh?
After a week, your lordship, from the week commencing from what?
When is coming?
Okay, after a week, my lord.
You have to be very sure.
Okay,
No
yes,
further adjournment.
yes,
It's
ma'am.
2019 matter.
Yes, ma'am.
List this matter after a week. We'll
Okay.
fix the date.
On 6th,
6/9/2023. No further adjournment, no further adjournment shall be granted on the next date fixed.
Okay, ma'am.
obliged,
Okay, yes, ma'am.
Tell your senior.
Okay, ma'am. Mas obliged, ma'am.
obliged.
Your Lordship, I would like to mention item number 11.
Huh?
Item number 11.
Item number 11.
Your Lordship, we're supposed to file an affidavit,
Why you have
So
not
we are-
filed?
so we need some more time.
Huh?
We haven't received like documents, all the
It's-
collected
it's-
documents.
Item number 11.
Your
It's for
Lordship.
hearing. When the matter is fixed for hearing, what's the question of filing affidavit?
Your
Where
lordship,
is
we have
Mr.
already,
Mr. D. Pangin? For the petition appellant,
we
what
have took the consent from the,
ah,
we only took the consent from the.
no, your consent doesn't matter. You are for?
Respondent
respondent.
side.
What affidavit you want to file? Are you in the,
Reply.
in the
Reply
matter?
affidavit.
Are you in the matter?
No, lordship.
Who's your senior?
Um,
What is this? What affidavit?
My
It's a regular first appeal. What sort of affidavit? What kind of affidavit you would like to file?
leading counsel instructed to instructed, so my lord.
Have you gone through the brief?
Yes, my lord.
What is that?
RF, my lord.
Have you found out something, the affidavit requires to be filed? It's a first, regular first appeal.
Yes, my lord.
Yes. Record is there.
Yes, your lordship.
Then my lord, some text.
No, no, I'm not, I'm not on fixing the date. We would like to know why the affidavit is required. What kind of affidavit you would like to file? It's a land dispute.
Yes, my
Yes,
lord.
your lordship.
Huh?
Yes, your lordship.
What kind of land?
Village, it pertains to the village land, your lordship,
Huh?
community land. Pertains to community land, your lordship.
Who is claiming?
Both of us.
There's a decree
Yes, your lordship. We have challenged the order of,
in favor of,
in
the
favor of,
respondent.
yes, your lordship.
Yes, my lord.
who is in position?
Position is,
Position is with you.
yes,
This is the reason
yes.
you want an adjournment.
No, my lord.
Any objection?
No, your lordship, but a short date may be given.
I don't know what sort of affidavit, will be- whether affidavit will be required to file here or. Tell us if it is really a. If it is necessary to file an affidavit, no issue. You may file,
Okay.
but normally regular first appeal and second appeal affidavit is not required. We'll go with the records. On the prayer of MS so and so, learned counsel for the respondent, list this matter after 4 weeks. 4 weeks. It's 2020, after 1 week
Okay, my lord.
or 2 weeks,
2 weeks, my lord.
list. After 2 weeks, huh?
Okay, much ob-
Obliged, your lordship.
May I please, lordship?
Yes,
Lordship, I beg to mention unlisted matter, lordship.
what sort, what is the urgency?
Your lordship, criminal
Can
petition.
we take up tomorrow? Huh?
Lordship.
Can we take up tomorrow? Can
lordship.
you not take up tomorrow?
Okay, lordship.
What is the urgency?
Yes, lordship. It's about drawing of payment, lordship.
Huh?
Drawing of payment, lordship.
It's no urgency after 4 weeks.
Lordship.
Huh? I mean, this is a writ petition.
Lordship.
It's a writ petition.
No, lordship. Criminal petition,
Criminal petition.
lordship.
Tomorrow we'll see tomorrow.
Okay,
There's no urgency.
lordship. Lordship, one more matter, lordship. I beg
Yes.
to mention item number 8, lordship.
Hmm.
Lordship, here we have recently received instruction from the respondent number 3, lordship. So we are filing, we have filed wakalanama, lordship, today.
We'll see. This is in the orders column. We'll see. You are wait for your turn.
Okay, lordship.
May I, your lordship?
Yes, which item?
Item number 28.
28.
Yes.
Ah. What do you want?
The PP is absent today.
Huh?
PP is absent today.
You are appearing for PP?
No, PP is absent,
Huh?
absent.
Are you appearing for PP?
No, no.
You are
madam.
appearing for whom?
Respondent,
Appellant? A petitioner? Huh?
respondent.
You are
Oh,
for
sorry, yes, petition,
petitioner.
yes.
What does it make a difference? You are not appearing on behalf of PP?
No, she is absent today.
Huh?
She is absent today.
Doesn't matter. We'll see. Why he should? PP,
Yes,
you are appearing for petitioner. Are you appearing for petitioner or PP?
yes,
Which one is yes? First one or second one? Yes or no?
yes, my lord.
Which one? Which one is yes?
First one,
What is first one?
petitioner,
You are for petitioner.
yes.
You said PP is absent today. PP is here.
Actually, your lordship, he meant to say the earlier Miss Jeannie was appearing in this case and he is well acquainted with the fact of this case. So maybe that is the reason she is submitting.
So you also, I mean, agree to her.
Lordship, not on behalf of the PP, but if the petitioner wanted to take adjournment, they can take
Where is
it.
the senior? Where is your senior? Mr. Pertin, where is he?
Mr. Patin is out of station.
Out of station. So do you want some time?
Yes,
You say so. You say that. MS so-and-so, learned counsel appearing on behalf of Mr. M. Pertin, learned senior counsel appearing for the petitioner. Press for listing the matter after 4 weeks.
after,
Prayer is allowed. Before that. Prayer is allowed. List this matter after 4 weeks. Mr. T. Learned addition to be present.
Oblige, your lordship.
Please, your lordship.
Yes.
Lordship, this is a successive pre-arrest bail application, your lordship, filed by the accused applicant. your lordship. Here, your lordship, some misunderstanding crop up between the complainant and the accused applicant, due to which a case was registered against the accused applicant.
So many sections.
Yes, your lordship, so many.
Where is the FIR? Let us see the FIR.
FIR is at page number 16, your lordship.
Ah,
Page number 16, FIR.
16.
16, 16.
Yes, read it.
To the officer in charge, Police Station Nalagan, subject FIR against Srimati Yagum Kabak, daughter of late Kabak Tachuk of C2 sector, POPS Itanagar district, fraudulently using my land allotment bearing byte number, allotment number NLG 12/10 of 2008, dated 15/10/2008, and forged my signature. Sir, in the context of above mentioned subject, I would like to inform you that one, namely Srimati Kabak, Yagum Kabak, daughter of late Kabak Tachuk, who fraudulently using my land allotment bearing by allotment number so-and-so dated so-and-so also receive of amounting of rupees 50 lakhs only in my name without my knowledge and consent. Moreover, by reliable source, it is came to know that he prepared.
Yes, yes.
Yes, your lordship, this
Call
is
for
successive
the-
bail.
Call for the city. Huh?
This is successive bail, your lordship. And
Is
for,
it?
yes, your
Yes,
lordship.
Your Lordship, I-
Successive, so your lordship, successive bail, they have to satisfy the court or they have to
Ah,
regarding new ground.
what is the new grant?
New
What is the
grant.
last order? Rejection order.
Rejection order is your lordship at annexure for page number 25.
25.
From 25. The earlier bail was rejected that it was in the nascent stage.
Ah,
The investigation has not been yet completed. That was, and more time may be given and accused applicant may hamper or tamper with the evidence. That was the ground, your lordship, the bail
Yes.
was rejected. Earlier interim was also given during the time of interim.
no, no, it's okay. It's okay. What is the new grant?
New ground, your lordship, she is still undergoing treatment. Regular treatment is going on, your lordship. Earlier also, before filing also, she was undergoing treatment at Delhi.
He or she?
Your lordship.
She has been, has she been arrested?
No, she's undergoing treatment and during your lordship interim, when interim was granted by this honorable court, she appeared before the IO of the case and given the statement, already statement has been recorded. Even in the CD, IO has also stated custodial interrogation is not recorded. Only more sufficient time may be given for investigation. That was the ground where bail was rejected.
Ah.
And it is too early initial stage. That was the ground.
You are not still able to say what is the new ground.
new grounded, your lordship, is still going under treatment. I have annexed some medical
If
prescription.
you say still underwent, that point of time also it was.
He was-
Consider, it was considered, your lordship, during the interim, when the interim bail was granted.
Ah.
And after considering all the aspect, ultimately the bail was rejected, your lordship. The interim bail was granted, your lordship, it is in annexure 3, your lordship.
That what is there? It's a perjury.
Sorry, your lordship.
It's a perjury, allegation of perjury.
Yes, forgery is there, your lordship, but the punishment is prescribed is life, your
Is it
lordship.
so serious or is it so?
The amount, your lordship, the forgery, by means of forgery, she have done all these things, your lordship. The only concern is so far as the merit is concerned, your lordship. I will confine to the case diary, so far as merit is concerned. My only concern is regarding the successive bail, the ground, new ground.
You tell us the
Yes,
success.
lordship, I have annexed, in my annexure 5, some recent medical prescription, your lordship. There is some series of medical prescription. She was advised to take bed rest. Annexure 5, page number 30.
Have you appeared before the IO?
Yes, your lordship,
Statement
during
is
time of
recorded.
interim, I was granted interim. I appear, I have given all the statement.
If it
And
is solely on your
moreover,
lordship,
Your lordship, in complainant have never said that his property has been took away by some other person from whom she have landed money. This is due to misunderstanding.
What sort of ailments you are having?
Ailment, your lordship, I am suffering from loose stool motion due to food poisoning, your lordship. It's earlier also I went for medical treatment.
Food
your lordship.
poisoning too, it hurt
And-
me.
it's a loose, your lordship, it's a loose motion, the stomach problem. This is,
And also I am taking.
this is not
Ayurvedic
so
treatment
serious.
also.
It's a common problem.
But I'm too weak, your lordship, only 47 kg.
If you take something,
Not totally, your lordship, I'm not fit, so.
foreign to your habitual food, it happens.
And
You
my,
don't take foreign foods,
some other ailments
you
also.
take a
is there.
food which is suitable to you or which daily you take. So it will
After-
be all right within a day or two.
After listening your lordship about the case, I just came back from Delhi. No, further.
No, it's okay. You tell us, forget about the ailment. Ailment and lose motion, it happens. It can happen to all of us. And it can be, you can get all right by within day or two.
But your lordship, my health condition is then not good, your lordship. I'm suffering from some other ailments. I'm being in a medical treatment for since last 4 or 5 years. That I have not
Besi-
enclosed. There are lots of.
Besides that, you tell us the subsequent ground. We'll grant you interim right now. You just
Your
tell us.
lordship, here, your lordship is the now complainant and the accused applicant.
Forget about the merit. We'll see. It's a, you are asking for a bail,
Yes, your lordship.
praying for a bail. So we'll see, as per the merit is concerned, we call for the CD.
Yes, lordship.
CD was produced. That-
CD was produced, and after perusal of the CD, only the bail was is rejected by this honorable court. The merit, everything has been
Show
considered.
us what is recorded,
Yes, your lordship.
page 25,
Yes, your lordship.
starting from page 25.
Your lordship, from 3, the submission by the petitioner, your lordship.
Hmm?
Submission by the petitioner, your lordship. May I read from para 3, your lordship? The what the abatement they have taken, what ground he has taken before the. It is submitted by the learned counsel for the petitioner that after obtaining the interim anticipatory bail, the petitioner received the notice and accordingly appeared on so and so and gave her statement before the investigation authority under section 161 CRPC. She was under medical treatment, and after giving the information, she has already appeared before the IO and gave her statement. Further, she is ready to cooperate with the investigation of the case if the interim pre-arrest bail is made absolute. Further, it is submitted that she is only breadwinner of the family and also looking after her 4 children, and there is none to look after her family, and hence in her absence, her entire family will suffer a lot. The petitioner is a permanent resident of her addressed locality, and there is no chance of absconding if she is granted the privilege of pre-arrest bail, and accordingly prayed to make interim pre-arrest bail order so and so. This is his prayer, your lordship. Now, your lordship, para 6, your lordship. The investigation officer of this case submitted that the bail objection along with the status report, and it is stated that the accused petitioner, being a government employee, has misused her position by fraudulently using official record and preparing fake agreement in order to take a due privilege of take huge amount of rupees 50 lakhs only from a person, and the case is at the initial stage, nascent stage of investigation. Hence, the bail of the present petitioner may affect the further investigation of this case. As per the report of the investigation officer, during the course of investigation, the said Srimati so and so was also called for, and her statement was also recorded under section 161 CRPC, wherefrom it also revealed that she was asked to put signature on some document on good faith. And she, being an uneducated lady, put signature on those documents without realizing any consequences. Further, it is submitted by the IO that when the accused person petitioner was examined, she stated that the gift deed agreement and the money receipt were prepared by her, which were paid in order to take
It's
money.
okay, it's okay. It's been more than a month. What is
Yes,
the
Your Lordship.
status?
Your Lordship, status for that status report, a CD has to be required. And Your Lordship, for successive bail, Your Lordship, the medical ground cannot be considered as a new ground. It's on humanitarian consideration. There should not be a cosmetic change. There may be variation in the law or the Your Lordship fact situation, which will directly add effect on the Your Lordship allegation against the accused, Your Lordship. Mere cosmetic change will not suffice, Your Lordship. There should be on allegation, there must be a Your Lordship, variation, Your Lordship. And which they have not come with that ground that what is that, whether there is exculpatory, inculpatory, or whether there is any favorable material.
Okay, it's okay. Bail was rejected on 24/7/2023.
Yes, Lordship.
24/7.
And
Yes.
she has not been arrested as yet.
Yes, Your Lordship.
Even after a lapse of a month.
Yes, Your Lordship.
So she may not be required.
Yes, Lordship, in.
Yes, she may not be required, but Your Lordship, my only issue here
What
is,
is
Your
the
Lordship,
purpose of arrest?
Your Lordship, in paragraph.
for interrogation, Your Lordship. And moreover, if there is a chance of hampering and tampering of the evidence,
She has already appeared,
Yes, it-
interrogated, and after your bail has been, her bail was rejected. And she has not been, called and she has not been arrested.
Your Lordship, in this regard, Your Lordship, I would make a humble submission, Your Lordship. In Katina of judgment, it has also been held, when
It's
even
okay,
if the
it's
charge
okay.
sheet is filed, Your Lordship.
Why are we oblivious of that?
But Your Lordship, the new ground, that's it. Otherwise, Your Lordship, what is the, Your Lordship, the
No, he's
judicial-
having an element, he's undergoing medical.
that can be considered. It's up to Your Lordship. That can be considered by this court, Your Lordship.
in,
It's a, Your Lordship, the ailment is.
IOCD also, they have said that further custodial interrogation is not required.
Where it
Already
is?
what, yeah,
Where it
Your
is?
Lordship, in paragraph
By whom?
by the IO.
Ah,
Your
Paragraph
Lordship,
four-
I have read out the.
Paragraph 4 of last line, Your Lordship, that
Which
How-
paragraph for?
paragraph 4, page number 27, Your Lordship.
27.
I'll read the bottom of the line. However, it is submitted by learned PP that the investigation officer has already recovered some of the relevant document in this case, and report of IO is also does not specifically say about the requirements of custodial interrogation of the present accused petitioner, Your Lordship. Whatever the document statement required, already
No, it doesn't say that the interrogation is not required. It said, it
Requirements.
has not been specifically said
Yes, exactly, Your Lordship.
about the requirements of custodial interrogation. Police has not said so. That was his submission.
yes, Lordship, but Your Lordship, every statement, every.
You saw us, besides your loose motion, show us something serious.
Also, he's also suffering from pressure, many ailment, Your Lordship,
Pressure is 75 and 95.
and some other,
Always 100 by 120, 150.
some other ailment also that,
And you are a government officer.
yes, Lordship, there is
You
no
have
chance
taken,
of my
you are
hampering
government
and
officer,
tampering, Your Lordship.
government employee, and then you have taken advantage of your position.
And here, Lordship,
How
there,
could you do
moreover, in
that?
FIR, there is nothing said that some other person came and have occupied that land or there. Simply only that I was not known that. And now the complainant and
What is the age of the applicant, the accused?
accused,
age?
Srimati Yagum Kapak,
47
What
years.
age?
47 years. Your Lordship.
47.
He's a government employee and moreover citizen of Arunachal, so there is no any chance of his.
This
If
aspect was
they are
already
really
considered. Your Lordship. This aspect was already considered. Your Lordship. Otherwise, it will amounting to review
no,
the
no, no.
order of the coordinate bench,
Let
Your
us,
Lordship.
let us do what they will call for the CD.
Yes, Your Lordship.
And then in tribunal grant, she being, she's suffering from some ailments, whatever. And she being a lady and a government employee with certain conditions. And we'll ask her to appear.
Yes,
in
Your
presence
Lordship.
before the IO.
So I will leave it to Your Lordship.
Oh, sir, with,
What do you say?
Your Lordship, I was
Also,
not succeed,
strict
but
condition,
Your Lordship, it's a
also,
discretion.
Are the merit, when you bring all the, including those, it will be open to you that whether the
Yes, Your Lordship.
the successive bail application in such situation can be maintained or not.
Your Lordship, I have the
So,
judgment, Your
leave it
Lordship.
open. Today we'll call for the. She being a lady and she being.
Your
a-
lordship, since your lordship, my only concern is your lordship, if suppose interim without granting the interim, if CD is called for, in that case, I have not any objection on maintainability
And you
because
assured that you'll not arrested.
so that how I can assure, because it is the, my investigation has, authority has the, your lordship, power, whether his custody is required or not, during the course of investigation, your
They
lordship.
have the power, not the whims of arrest, power to, at their homes to arrest. They have a investigate. That's the reason I pointed out. One more than a month, had lapsed.
Whether your, that is the issue, your lordship, whether the,
Your lordship, the agree person, the complainant have no.
I think you will not be arrested.
Still, your
After
lordship,
the rejection of your bail, she has not been,
Your
are
lordship,
you absconding?
no, your lordship. I'm not absconding. I'm still going with my
So
medical treatment.
we'll fix on, short date we'll fix, we'll call for the city, we'll see.
Your lordship, if she's a woman, your lordship,
Or
after,
Mr. So and so, Bhattacharya, na?
yes, your lordship.
Arup Bhattacharya, learned counsel for the petitioner. And also had Mr. T. Atelan, additional public liability for the state of Arunachal Pradesh. This is a subsequent bail application under section 38 of CRPC, 1973, for the grant of privilege of free arrest bail. To the applicant in connection with Naharlagun PS case number 111 of 2023 under section 409, 420, 423, 465, so page two, huh? Of IPC. Next paragraph, the bail application. The bail profile was rejected by this court on 24/7/2023 in bail application number AB 40 of 2023. The learned counsel for the applicant submits that the subsequent application, the present subsequent application has been filed on the ground that the applicant accused is undergoing medical treatment due to various ailments. He has already appeared before the IO and recorded her statement after the interim order was granted by this court. Interim order was when?
Interim order was your lordship on
19/7,
19/7.
2023. The learned counsel submits that even after lapse of 1 month of the rejection of her bail application, she has neither been called and no further interrogation has been made to her. Latter part is continuously undergoing a medical treatment at Delhi.
Earlier, she was undertaking treatment at Delhi, now at Hema Hospital,
Okay,
medical checkup.
at Naharlagun. Call for the case diary. Can copy or what?
yes, sir, scan copy may be called.
Call for the case diary. Next paragraph. Considering the.
Your lordship,
accused-
I pray that interim may be given, there will be no harm, she will not hamper temper with your lordship, any witnesses connected with the case. Even the complainant also is not pressuring the investigation agency. There is
We'll fix it
nothing-
after a week. It's
Sorry,
not
Your Lordship.
Naharlagun. We'll fix after a week.
Okay, your lordship.
Ah.
On, Any fixed date, Your
Next
Lordship?
para- Considering the applicant accused being a lady and a government employee, coupled with the fact that she's undergoing medical treatment. This court deemed it appropriate to grant interim bail to the accused applicant. Accordingly, in the interim, the petitioner, the applicant accused shall appear before the IO within 3 days. 3 days, within 3 days. Listen, on such appearance, in the event of arrest, the applicant accused shall be released on bail. On our executing a bail bond of rupees 50,000.
Your Lordship, it will be too much. I am government
50,000.
employee, Your Lordship. Earlier also,
With one local surety of the like amount to the satisfaction of the arresting authority on the following conditions. You just keep page 24. Huh? The petitioner shall not make herself available for interrogation by the, no, this will not. The applicants accused shall not hamper or tamper with the evidence. The applicants shall not leave the jurisdiction of shall not leave the jurisdiction of the Naharlagun police station without the written permission.
capital complex also it can be, Your Lordship. Capital complex also.
We will say Naharlagun.
Naharlagun. Without prior information to you.
Huh?
Without prior
No,
information.
without written permission,
Yes, okay.
so that you can
And Your Lordship,
finish this matter after a week.
there was only one prayer, Your Lordship.
Ah.
My submission regarding maintainability may be reflected, Your Lordship.
The last, the question of maintainability of the present bail application is kept open.
Yes, Your Lordship.
The kept open and the same shall be heard on the next date.
On 7th September, Your Lordship.
So we fix that so that we can, it will be convenient for us to call the case there. 7th,
7/9.
okay.
Deeply.
You have to appear within the.
Yes, Your Lordship.
three
I'll
days.
appear tomorrow itself, after getting the order, Your Lordship.
All right.
Will issue notice?
My lord,
We'll call
yes.
the TD.
Yes, my lord.
It's a regular bail,
Yes, my lord.
not Mr. So and so.
In this case, my lord, the impleadment of the victim would be necessary, my lord. Impleadment of the victim
When you.
or the
implement-
informant, my lord.
My
This is
lord.
the offense is,
Yes, POCSO under section
then,
8.
then you implement first, we'll take up tomorrow.
My lord,
It's a regular bail, we'll take up
yes,
tomorrow.
yes.
Or you file a fresh impleading the.
Yes,
victim
My lord,
Yes,
there is a
Or the informant.
judgment.
With a-
Much better.
much obliged.
18 and 19 arising out of same FIR, Your Lordship. And it's a regular bail call for the case there, Your Lordship.
Huh?
Regular bail, is
Same FIR,
same FIR
same order.
for
Same
both the
offense,
cases. Same offense.
409 IPC, Your Lordship.
34 is there, common
The
intent.
case connected with ROPS case number.
But this is regular bail.
Yes, Your
For
Lordship. Call for
accused
the-
are in the.
Mr. So and so learned counsel for the accused. Also. Mr. T. at the learned additional prosecutor for the state government of the police. Put a base diary.
list on 12 maybe. Your
Based
Lordship.
on 12/9/2023.
Obliged, Your Lordship.
The case there he was called for in item number 17. The case there is there.
17,
7, item 7,
item 7.
born out of the same FIR.
We'll see at that point of time, then what is the same person,
Complainant is the same person, my lord.
but the accused are different.
Accused are different.
So we'll issue, I will call for the
No, my
case
lord.
diary has been called here.
In item number 7
Hmm.
of today's list, the case diary was called for.
Hmm.
And this matter may be taken up along with this.
Item 7.
Yes.
PP? Who is appearing? Item 19?
Your Lordship, 18 and 19 is same matter, Your Lordship.
Okay,
In 7,
it's 20.
yes, sir.
Yours is 20. Okay.
20, yes, 20 and 21. Along with, my lord, this, along in item number 7,
Yes,
the case diary was called for. It is connecting to the same
you
FIR.
are appearing item 7.
Your Lordship, the other matter which my senior colleague is, Your Lordship, apprising is, that matter is being looked after by my learned sister, El Hage, Your Lordship.
Hmm.
So I don't have any idea about what is the fact of the case, Your Lordship. She will, perhaps she will appear.
What is the offense here?
My lord,
Let us see.
326. My lord, this, the ear of the victim complainant was beaten off by the alleged accused person.
No, this is, you have, this is listed for the first time. Can you not issue a notice to the
No.
public prosecutor?
No, but
We'll just issue the notice public, when the matter is taken up.
Now-
When you take up the matter as item 7, we'll see it.
correct,
At this stage, we'll issue notice to the
Notice.
PP
PP.
or Mr. Titi. There are learned counsel for the petitioner. Applicant accused. Next para. Issue notice to the public prosecutor.
Yes. And tag,
When
and tag along with item 7, my lord.
21 and 20,
And take
20 and 21.
tag along with item 7.
List this, I mean, take along with the, take this well application with well application 7/7 of 2023.
Much obliged.
We'll see.
Obliged.
Yes,
Worship, this is a joint petition under section 482.
yes.
For portion of FIR, portion of charge sheet, Your Lordship, dated charge sheet number 01 of 2022, arising out of FIR dated 6/9/2022, Alo PS case 50 of 2022.
What is the stage of
This is now, next will be for CC. It was till now, it was in appearance. And Lordship, this is the family dispute, Your Lordship. Family dispute. The informant is the brother of the accused.
It's 380.
Yes, Lordship.
380 is what? Theft.
Theft, Your Lordship. Theft, Your Lordship. Lordship, the allegation is the accused person is a alcoholic drunkard, and he has stolen some property from some things from the house and sold it for money, and he started asking money from the mother. So mother is made the victim here. Now, after that, he was arrested, and the bailer, he was the bailer was the mother herself, the victim. So it's a dispute between the family.
But then this is a theft.
Yes,
And you are admitting that is a theft.
Lordship, in they,
You are admitting that you have stolen
Your
and
Lordship,
sold it. So you are admitting
and
it
now after,
only after the framing of charge, whether you should be, what kind of,
the Lordship, it's more of it's, their own house, he's selling their property, but
No,
just
you-
that there was a
but then-
dispute between the brothers because of
you
the
are
property.
you are pleading guilty.
No, Lordship,
No, just commit, committing an offense
yes,
is one thing. But you being the member of the family or relatives is quite another thing. Within family also, within as a brother, I mean, within the family also, there can be a theft also, is not it?
Yes, Your Lordship.
Just because you are the family member,
Yes, yes.
you cannot say that no offense of theft can be made out.
Yeah,
By your own submission, you are pleading guilty that I have committed a theft. But then just because I am the younger brother or whatever,
No, Lordship, of course, the offense will be made out. There is offense, Your Lordship. But because they are in the same.
so that's exactly what you are admitting that there is an offense. You have committed the offense.
No, Lordship, I'm saying that the offense can be made out. It's just because in the house somebody has stolen. Doesn't
You
mean-
pleaded before the London trial court and then plead for leniency.
Lordship, this is a joint petition. Your Lordship. They have already, by
So
continuing this case, the
it
accused
is,
is suffering, but
it-
more of the family, the informant and victim are suffering because they are the one who is paying for the bail and
that
everything.
is, somebody yesterday told me 191 is there,
Sorry, your lordship.
section 191.
190.
Let us see,
CRPC or IPC or CRPC?
IPC,
Section 90
191.
or 191. Giving false evidence.
Yes,
It's punishable, your lordship. Punishable under and procedure is provided under section 195, your lordship.
not 195 simple. Will issue notice. Right,
Lordship,
Mr.
can interim maybe consider.
no interim, you have, by your own submission, how the interim order can be granted? How the interim prayer can be granted?
Interim for staying the.
At least you could have said, I have not committed an offense. Before this court, you are saying that I have committed an offense?
And
Of
Lordship,
course,
I'm
on
not
certain
saying I've
grounds.
committed- The allegation, I'm talking of the allegation was made that in the FI, it is made that he is a drunkard and he has stolen some property and sold it. For that, they have lodged an FIR
Hmm.
and for that, he has been arrested.
Hmm.
But now, after charge sheet, they have already settled the dispute. There was a misunderstanding and dispute between the
What,
families.
what is your statement?
In paragraph 5.
No. In the statement before the police. One 61.
Yes, your lordship. I don't have the brief.
Huh?
I don't have the brief, your lordship.
You have not given him the thing. Huh?
We have already served notice, served a copy to the.
Hard Mr. Swenson, learned constitutional petitioner. So heard Mr. T at the learned addition, public prosecutor for the state of Arunachal Pradesh. By filing this application under section 482 of CRPC of 1972, the petitioners jointly prays for washing the charge sheet number 01 of 2023, dated 18/1/2023, arising out of all of PS case number 50 of 2022, corresponding with GR case number 105 of 2022 under section 380, 506, 384, pending before the Chief Judicial Magistrate. What do you mean? What do you mean by Chief Judicial Magistrate first class?
Lordship, they have mistakenly written it's a chief judicial, first class, it's chief judicial magistrate.
Who will correct this?
Yes.
Do you want that it has to be corrected by the court? Who has written this?
Lordship, one of my associates has drafted.
Ah. So look, kindly correct it and we'll pass an order. Huh? You know that then you are misbothered to get it corrected. This is something as a how long you have been in the practice?
3 years.
3 years. What do you call a budding lawyer? As a budding lawyer, when you know there is a mistake and you have chosen not to correct it, this is something may have a far-reaching consequences in your career. one could understand if you have not noticed it and if you fail to notice it. But having knowing fully that there is a mistake, no matter it may not have a bearing, but it's a pleading, part of the pleading.
Lordship, I'm sorry about that, Your Lordship, but by the time I noticed the file was already here, so.
But is there, but once the file is here,
No,
you
Lordship.
cannot get it corrected.
No, Lordship.
You cannot correct it. You couldn't pray for it.
Your Lordship, kindly allow me to make necessary correction. In that case, Your Lordship, allow me to file afresh, Your Lordship.
On the prayer of Mr. So learned counsel for the petition applicant. The criminal petition is permitted to be withdrawn. Accordingly, criminal petition is crossed on disposed of on withdrawal with a liberty to file a fresh so advice.
Obliged.
It's for you, it's not for us.
Of course, Your Lordship, of course, Lordship.
We want all of you to go up in the profession,
Yes, Lordship,
especially this court once,
of course, Lordship.
whatever little bit we
Obliged,
can,
Your
contribute.
Lordship.
I mean, support you.
Obliged.
Be careful next time.
Yes. Yeah, Lordship.
Yes.
Lordship, this is a criminal appeal under section 378, subclause 4. Along with this criminal petition, Lordship, we have filed a criminal leave petition. Along with this criminal appeal, we have filed a criminal leave petition, which has been numbered as 2 of 2023.
Yes.
Lordship, what has happened in this matter is that I had the appellant, that is the complaint in the CGM UPI, had filed a complaint case under section 138 of NI Act against the respondent, that is the alleged accused. Lordship, that during the trial of the case, the trial is always on verge of completion. After taking the 313 of the alleged accused, now that is alleged accused, it's now the,
So we'll issue notice.
yes, Lordship.
With the other party also. Is that it?
Yes, Lordship. Lordship, with this, my criminal leave petition may be disposed of, saying that I'm taking the prayer of this honorable court to file.
No, since there's a respondent, we'll just hear that we'll issue notice. So we'll take a steps,
Yes, Lordship.
in this leave also.
Yes, Lord.
He may have to say something.
Okay.
All right.
Right, Lordship.
Or what is the procedure? Mr. PP? What is the procedure?
Okay, Your Lordship,
You find out, we'll issue notice.
Yes, Lordship. Lordship,
If he is not there.
no BP, it's a private.
private companies.
Yeah, that's why they should leave.
Hmm.
Mr. B. Jamal Learned Counsel for the petitioner. Had Mr. B. Jamal Learned Counsel for the petitioner. Will issue notice in the criminal leave petition.
Yes, Lordship.
The petitioners who are filing this application 6 special leave to appeal against the order that in 27/2022 passed by the Learned Chief Justice Administrator in CR case number 96 of 2019 in the section 138 NI Act. Issue notice returnable within 3 weeks.
Lordship, 2 weeks, as well as
2 weeks.
justice service, Lordship.
2 weeks. The Learned Counsel for the petitioner said take steps. Service of notice upon the respondent within 2 days. Respondent by registered was with AD as well as
Justice service.
Dusty.
Yes, Lordship.
Dusty within 2 days.
Within
This number,
2 weeks.
2 weeks.
Develop, Lordship.
Returnable 2 weeks, huh? Yes,
Lordship,
yes.
also this is joint petition filed by
What
the
is the offense?
offense is 354, 1 A, 1 I, /354B/323. The charge framed by the learned
354A,
354A
one,
1
354B.
B, yeah. No. Lordship, this is the joint petition filed by the petitioner 1 is the alleged accused person. Petitioner 2 is a informant. In connection with
How you are related?
uh,
Are you related?
no, I totally deny the church, but still then
No,
the
no,
court
what is
below.
the relation between petitioner number 1 and 2?
So petitioner 2 is the tenant and I am the landlord. Petitioner 1 is the landlord. She stay in my house as a tenant with
Yes.
family.
That is more dangerous.
Yeah, Lordship, the fact of the case that there was some issue of the payment of the rent. So out of the, their misunderstanding arose and petition number 2 filed a FIR against me. So accordingly, case was registered at ITAP PSK, Omen PSK number 157/21 under section 1.
What is the stage of trial?
The stage is initially is that this charge has framed
Yeah.
against me.
How many prosecution witness?
Witnesses,
Evidence, how much prosecution evidence?
not yet,
Witnesses?
not yet. It is initial stage. Only
Just-
notice has been given,
Charges have been framed.
charges are framed. And Lordship, and settlement has been arrived, mutual settlement, not compromise,
Let
mutual
us see the
settlement.
nature of your settlement.
Page
After
number, Lordship, page number
after committing such an offense,
52, Lordship.
these things are allowed to go on.
Yeah, page number 52, Lordship.
53,
52, that is annexure 5.
yes.
Mutual settlement. This mutual settlement has been made today on 15th day of July 2023 between so and so, that is petition number 1, and so and so, petition number 2. The brief fact of the case is that due to some misunderstanding with alleged accused person so and so, rent owner on 7/10/21, FIR was lodged by the complainant so and so by the informant before the Oman Police Station, Itanagar. Accordingly, FIR was registered at Oman PS case 157/21 under section so and so. So Lordship, this 354 is no more, and 354A1 I clause I subclause I/354B and 323 only the charge framed by the land court below. Lordship, in connection with the above mentioned case,
That's why I'm asking, when you said that complainant, the alleged accused are close relatives, what sort of relation you are?
a close relative is
it a-
matrimonial,
is it a-
matrimonial relative,
Matrimonial?
matrimonial relationship. Since still they are living in the same place, same location, that is New Jersey village 1, nearer just Lordship nearby only. They are still together in the same place, same locality. And in this alleged accused person secured pre-arrest bail from the appropriate court and same was made obsolete after appear before the investigating officers. The instant case was charged is seated by 166 of the 21
Okay.
against
Heard Mr. Nabam Begum, learned counsel for the petitioners,
Lordship, Arnabam,
Arnabam.
yeah. Regum Nabam.
Okay. You have changed it.
Yeah, just that was desire of my father, so I changed. Lordship,
Heard Mr. R. Nabam, learned counsel for the petitioner. And also heard Mr. T. A. learned additional public prosecutor for the state of Arunachal Pradesh. This is an application under section 482 of the
yes,
CRPC, 1973. Praying for quashing of the proceedings of GR case number 94 of 2021, arising out of woman police station Itanagar, number 157 public 2021. Corresponding to GR case, what is it?
here case number 394/21.
Oh, okay, sorry. Pending before the chief judicial magistrate. Sorry, before the under section 354A. Within bracket 1, Roman 1, small Roman 1, bracket close 354B. 323 IPC, pending before the chief judicial magistrate. UPI. On the basis of the compromise between the
Yes, sir.
petition number 1 and petition number 2. That's correct. Call for the LCR, skin copy. of the LCR.
So in the meantime,
Pending production of this LCR. The proceedings of GR case number 934/2021. Pending before the Indian Chief Judicial Magistrate UPR. Shall remain suspended.
Master.
Shall remain stayed.
After 4 weeks,
This is after 4 weeks.
oblige.
May I please, Lordship?
Ah,
Lordship, this is a application under section 482 of CRP.
did you have any idea?
Your Lordship.
Have you had any idea that parties have consulted in this matter at one point of time? To me, to this,
No idea.
okay. I remember, I recall yesterday. Any other appropriate bench?
Yeah, Lordship.
Yes.
Lordship, this is the regular course appeal against the judgment and order rendered by the Ernest Civil Judge Senior Division.
Yes.
The judge. Lordship, here, like, basically, we are not, like, here the appellant. There is the, defendant in the lower court below had taken in sum of 1 crore 70 lakhs from the respondent, that is the plaintiff in. And also during the trial in our WS also, we have not objected of taking the amount of 1 crore 70 lakhs. And we have made in averment in our WS also that we have refund back the amount, and the amount of 60 lakhs which is remaining, that we are ready to pay. So with that, Lordship, in our
What you want to, what you are ready to pay? How much?
Lordship, as
What
of
is the decreed amount?
the decreed amount, Lordship, may I take, it's like, we are not,
How you are agreed?
Lordship, we are agreed with the amount of interest in, imposed upon us by the Learned Civil Judge Senior Division. We are not,
What is the amount?
amount, Lordship, that which,
Madam, my lord, it is around 3 crores 32 lakhs till date, if we, in the last calculation of the interest. Already they have,
If not, what is the principal amount?
principal amount will be, my lord, 1 crore 70 lakhs.
that we have paid.
How much you want to pay?
Lordship, we are ready to pay as per the provision given by the CPC. Section 34 of CPC says that is 6% per, as per the CPC, Lordship.
My lord, if today, just to interfere, my lord, if,
Then in that case, we'll admit.
my lord, my
records-
lord,
records-
if they're seeking for stay of the
records
judgment,
Have been called.
Yes, not yet, Lordship.
my lord, I'd like,
Then we'll call for the records.
Yes, Lordship.
my lord, before any proceeding, my lord, is this being an appeal file under order 41. My lord, may I take your lordship to order 41 rule 3 of the CPC? It's at page number 263.
Along with this, we ought to have filed an IA for stay of the judgment. That if I'm not wrong, my brother would say that only, but
You are
No,
not-
my lord,
You are not pressing.
another aspect. Order 41 rule, I like to read order 41 rule 3, my lord. Page number 263. Down below. Order 40.
Appeals from original decree.
Yes, ma'am.
Ah.
My concern is rule 3. Where the appeal is against a decree for payment of money, the appellant shall, within such time as the appellate court may allow, deposit the amount disputed in the appeal or furnish such security in respect thereof as the court may think fit. My lord, before submitting of the security, this appeal cannot go on. My lord, they are challenging the decree and judgment of the lower court below. So my lord, at least before the proceeding of hearing of this appeal, as per this provision of order 41 rule 3, they ought to deposit some security before this honorable court.
What is the disputed amount? 3 crore something,
Yes, my lord, including
But-
the interest.
huh?
Because in the judgment only, principal amount is 1 crore 70. But in the decree, there's even including the interest amount, it comes up to 3 crore 32 lakh something till date.
Including the principal.
Yes,
Forget about he said principal amount he has already paid.
Yes, Lordship.
he is
they have
partly paid. Yes.
Not partly paid, we have paid the principal.
No, principal amount according to him, 170 he has already paid. The
So-
dispute is the amount, I mean, the.
Interest amount.
Interest amount.
Which he said that it should be 6% per
Yes.
annum.
Yes, Lordship.
The trial court, I mean, lower court has.
It's decreed 6% only.
6%.
As per the
No,
judgment.
Lordship, may I read out that this, I'll just take to the operative portion of my page 23, Lordship. Yes, like,
We'll just come to you. I'll just, let
Right.
me know the. Page
page 23, Lordship, the operative
23.
portion, yes,
23.
yes.
Yes,
May I read, Lordship? It says, in the result, the instant money suit is decreed in favor of plaintiff with a cost of 10,000 along. According, the defendant is directed to pay the 61 lakhs only to the plaintiff with interest rate of 3.5% per month on the principal sum from January 2019 till the date of filing of the suit. That is the pre-suit has been imposed upon us with interest rate of 6% per annum on the principal amount adjusted from date of suit to the date of decree, with future interest of 6% per annum from the date of decree to date of payment. And this 61 lakhs, Lordship, they have filed an execution petition before the learned civil judge senior judge, and we have paid the principal amount. Now we are only with that 3.5% per month on the principal from January 2019, when the promissory note was executed between the appellant and the respondent. That which is more than the Lordship, the,
this 3.5.
yes, Lordship,
With regard to 3.5, you have
3.5,
executed promissory note. Huh?
yes, Lordship.
Promissory note was regard to interest, 3.5% per month on the principal amount.
What is disputed then? 6%.
In this appeal, yes, they're disputing this judgment order 6% in that.
Actually, by now, you might be agreed of all the, I mean, decree, but then actually what you are, how you are, what you are agreed.
Lordship, we are in our.
How much you want to pay?
Lordship will pay as per the CPC given section.
Forget CPC.
Mhm.
In that case, you have to deposit as per CPC also.
Lordship,
Yes.
for that we have paid the amount, the principal amount after the render of this judgment, the impugned judgment. So we are ready to pay the amount, Lordship, as per after filing of the,
How much you are, according to how much you have to get now? Actual amount. According to decree,
1 crore 70 is the principal amount.
that he has already paid.
Yes.
Then
But my lord, that after that 6% interest, it comes up to 3 crore 32.
minus. Not including the 167.
My lord, my calculation is as per as per the agreement was 3.5% per month from the principal amount. So in the lower court below,
It's okay, whether this includes that your total claim. As on that, as per your calculation, whether it includes the principal amount or it's a minus principal amount.
minus principal, no, minus principal amount. Minor, be that as it may, minor,
How much you want to pay?
Lordship, the
Have
interest.
you calculated as per the decree, how much you're supposed to pay?
Lordship, I've been instructed that the appellant, that is the defendant, and they are ready to pay the interest amount after from the date of filing till the judgment is rendered in that case. Not that they've given the pre-suit also, Lordship. That's what we are agree with 3.5 percent, that it comes up to 12% in a year. So that is more than the principal amount which I have taken from them. So we are only, Lordship, if we calculated the principal amount 3 point, it goes on to 93 lakhs 94,000. That is, which is more than the principal amount which I have borrowed from them. And as far as interest rate also, it says that the interest rate cannot be more.
Whether the law prohibits that,
Law doesn't prohibit,
Suppose you
doesn't
have-
allow that law. That's
you have borrowed
Mm,
and with certain conditions,
mm.
huh? And then you have not repaid back. Whether it's less than or bigger than a principal, it doesn't make any difference.
That's why Lordship, if
But
else-
I am on mediation.
Mm.
Can you, how much you want to, would like to offer to pay? And how much you would like to agree? If you don't have any agreement, it's okay. But if you can settle. Huh?
My
What
lord,
do you say? You will go by the decree
my lord,
on merit,
merit,
no compromise, no settlement.
no, my lord.
Lordship, that and that we will argue on the merit of the case. So for that LCR.
And
LCR
my
will
lord,
be
that is
recorded.
why, my lord,
In that
I
case,
told-
we'll call for the records.
And Lordship, since there is an execution petition before, that may be state Lordship.
my lord, order 41 rule 3. That's why, my lord, I'm taking this attention of this order.
And during,
What is your petition for stay?
on that Lordship, we have not.
They have not filed.
If in case without
Will
filing,
that-
then you may
Moreover,
file
my
an
lord-
appropriate and you may file, you may also file an appropriate application.
My lord, order 41.
Yeah.
Lordship, since
These are Learned Council for the upper land. And also have Mr. H.K. Learned Council. Respond with. Call for the reports. Parties may file appropriate. Application. Parties are permitted to file appropriate application. So you just delete it. Call for the record. Just after 4 weeks.
After,
When? 4 weeks,
after 2 weeks, Lordship.
after 2 weeks.
Develop.
Hmm. 23.
Yes, Lordship. Lordship, yesterday the honorable court was, to know whether section 354
Yes.
on the IPC can, like, on mutual deed of agreement, compromise can be. On that basis, can the FIR be questioned?
Hmm.
Lordship, I have gone through this, Kapil Gupta versus State of NCR Delhi, where is the Lordship, 36 and 376. On the 376 case was also. The FIR was on mutual agreement between the parties. And Lordship, I have brought some judgment of High Court, which says Lordship, on mutual deed of agreement, settlement, on settlement between parties. The FIR proceeding can be quashed, Lordship. If I may be allowed, Lordship, yes, and like Chhattisgarh High Court. It's a small judgment, Lordship. You. Here also, may I read, Lordship? The paragraph 2 is offense punishable under section 354, 296 and 506 of IPC. Lordship. Here, Lordship, in paragraph 7. taking into consideration of rendered by the Gyan Singh versus State of Punjab, has caused the criminal proceeding on a mutual deed of agreement between the parties. May I read also?
Yes,
Here also Lordship on the mutual deed of agreement between the complainant and the accused. Lordship, the High Court was pleased to pause the criminal
they
proceeding.
relied on the Gyan Singh.
Yes, Lordship.
Thereafter, all these Gyan Singh and everything have been considered by the apex court.
And other also Lordship was Delhi High Court judgment, it's 2021. Here also Lordship, the section where 354, 354A, 354B and 354C is all were
No, you give us the judgment of Honorable Apex Court.
Apex Court Lordship, I would give the Kapil Gupta versus State of Delhi, wherein there was an allegation of rape and that took place between the complainant and the accused also. But here also the Honorable Court that said since the border party had moved on and they are living their own life happily and has caused the criminal proceeding against them. And Lordship here, in our case, this section 354, wherein Lordship, I have yesterday also have told Honorable Court that the petitioner number 1 is the best friend of petitioner number 2 younger sister.
That is the whole difficulty.
Since they are not from the same area, from the same place, and as of now also they are like they visit each other house, and they're living a peaceful life together. Lordship, so this is a fit case, Lordship, I would say, because what has happened that matter took place in between the petitioner number 1 and 2 in a night that was inside the car, inside his vehicle. So it's a private in nature, Lordship.
Let us see the Kapil Gupta.
Kapil Gupta.
Which paragraph?
Paragraph, Lordship. Yes. What's our straight we come to from paragraph 16. Lordship, here the Kapil Gupta has discussed the various previous judgment notes. Paragraph 13, Lordship, may I read now? Insofar as section 376 IPC is concerned, it is well established that the offense punishable under is committed not only toward a victim but against the society. In consonance with the view taken in Narendra Singh and others, court have won in a plethora of decision against the consequence of permitting compounding the offense punishable under section 376, including Simbu and other of state of Haryana reported in so and so, where it has observed that further a compromise enter in between the party cannot be construed as a leading factor based on which lesser punishment can be awarded. Rape is a non-compoundable offense and it is an offense against the society and it's not a matter to be left for the party to compromise and settle. Since the court cannot always be assured that the consent given by the victim is compromising, the case is genuine consent. There is every chance that she might been pressured by the convict or the trauma undergone by her all the year might have compelled her to opt for a compromise. In fact, accepting the proposition, it will put an additional burden on the victim. The accused may show all his influence to pressurize her for a compromise. So in the interest of justice and to avoid unnecessary pressure harassment of the victim, it would be safe in considering the compromise between the party in rape case to be ground for the outcourt as a discretion for under section provision of section 376 subclause 1. This instance case has been referred by the Supreme Court of the State of Madhya Pradesh, Bas Mandal reported so and so, wherein the court observed that concept of compromise in case. This all just go to section 16 or paragraph 16. Where in the back door of this legal position, court have referred from exercising power under section 482 CRPC to quash in respect of heinous offenses, especially those under section 376 on the basis that a settlement has been arrived in between the accused and the complainant. Which is referred number so and so and other report 2019 instead of under report on 2002 SC online so and so and reported lately this court is Dr. Mahadip Kumar Meenabad State of Guam Delhi and other reported in 2001 SC online held that even though party had prayed for causing on a basis of inter say settlement, the prayer could not be accepted. Keeping in initiation of referral background here, the court is opinion that even though both parties have prayed for causing the FIR on the basis of inter say settlement, the prayer cannot be accepted according to the reason has to exercise inherent jurisdiction under 482 is not mirror. In view of the conclusion error here, the present or this is dismissed. Here lordship in this Kapil Gupta, there was a.
This is of Delhi High Court.
This is of Delhi High Court.
I'm talking of Supreme Court. It goes against you.
It goes against Kapil Gupta. I have placed the wrong judgment. It's Delhi 2022 SC online. This is different. This is Delhi High Court. Yeah. Lordship here in other case also in it's a Supreme Court high judgment. High Court of Gujarat Supreme Court 2010 Supreme SC again. Here also the section involved is section 354B. Section 395, 397, 307 and 354 of here there was also mutual agreement between the victim and the accused. Lordship, the paragraph 8 and paragraph 13 will be the operative portion, Lordship.
Is it Gujarat High Court?
This is Supreme Court.
Huh?
This is 2010 Supreme Court of Gujarat.
Gujarat High Court.
Gujarat.
Huh?
Yes, Lord.
I'm asking the Supreme Court judgment of Kapil Gupta.
In Kapil Gupta Lordship, State of NCT 2022 SC online. Here, Lordship, the operative portion, the Supreme Court held that while exercising power under 482, the court should be slow in pausing the proceeding, whereas heinous and serious offense are involved. Lordship, here in our case, it's not a heinous offense, it's a 354. And that was also private in nature between the two parties. But it's is
Delhi, Gujarat,
Hmm.
and
Then Lordship, this Delhi High Court is Kapil Gupta versus NCT of Delhi, 2022.
Delhi High Court.
Delhi Supreme Court also, it's, Lordship, this is the Lordship judgment of Kapil Gupta. Right from Lordship, paragraph 13, Lordship, it would be like. Mary Lordship.
what is the stage of
Lordship, the charge has been framed against the petitioner number 2. And now the trial will, since there is a stay by this honorable court, the proceeding has been given events. Since Lordship, this is in an initial stage, Lordship, when the trial goes, it will be futile exercise of.
what is your agreement?
Agreement, Lordship, which I have in page 41. Page 41, Lordship, this is the between petitioner number 1 has been made as first party and petitioner number 2 is second party. Lordship, here the incident took place on 12/8 of 2019 and the complaint was made after a gap of 3 days, Lordship. That
Yes.
Your Lordship, yesterday, my learned has submitted that it was outcome of payment enmity. And in that response, I submitted before this court that if there is an outcome of enmity, then this settlement agreement is void ab initio. If settlement is not there, then proceeding has to go on.
Settlement agreement is what?
Void ab initio.
Why?
If there is a enmity, if there is a inducement, if there is a threatening, and if it's out of context, then it is
How do we say that it was, they were forced to settle the matter?
yes,
On what basis you are saying so?
on the basis of submission made by this.
Don't make by submission, you go by the records.
Yes, record says that here petitioner one admits
Just giving.
admits
Hmm.
in
You said first you said this settlement agreement is void ab initio.
yes,
Why?
if there
Is
is
there anything to show
no,
that this settlement was
as
done
per record it is
under duress?
as per record it is not
If
incorrect.
it is not record, why you are making a submission? That's why this scanned copy has been called.
Yes,
Go by records,
record there is no any
records
such.
and the law. First make a submission on the basis of the record.
No, in
Then you
just,
come to-
only
come to the law.
submitting on the
No,
in response to submission made by the
see, Leonard PP, we are not here to witness the cultural program or the circus. Since the record is with you, you make a
Yes.
submission on it. Just
Here,
don't make a submission,
as per record, your
whatever
Lordship,
you like.
yes, as per record, clearly offense charges framed against the accused person is clearly established. Prima facie it is there. Prima facie
What offense?
offense under 366,
366?
yes, kidnapping for compelling to marry. And statement is 164 is also there of the victim girls.
Have you gone through the record?
Yes, it's inconsistent with FIR 161 on.
So have you gone through the record which you are holding now? Was the question of kidnapping? Where does it come? The kidnapping comes from where?
No, earlier on the
Just because it's mentioned in the church sheet. That's why I said, you want to, please go through the records and make a submission.
yes, I'm on the record, Your Lord.
Yes. Have you seriously gone through the record?
Yes, as per the friend,
So
friend-
as well with the question.
friend of the victim and who is a sister of the accused. As per he went voluntarily.
It's okay.
Ah,
You said in it, first you said kidnapped.
no,
So as well.
then in the pretext of dropping her to her rental house,
Is it a kidnap?
he forced her to take away from.
Can we conclude that if somebody on the pretending of dropping took away somewhere,
Yes, by locking the car door,
so it is a kidnap?
it was force was used against her will, against her consent. Force was used. It is for the third court to be decided whether there's ingredients of kidnapping is not or. But as per charge, as per charge framed by the trial court, 366 framed,
It's okay, it's okay.
354. And you're also repeatedly,
Why
repeatedly, honorable,
See, why we should not rely on the compromise deed?
repeatedly, honorable apex court.
Settlement deed.
Yes,
Why
yes,
we should
I'm coming to that point. Repeatedly, honorable apex court reiterates that serious and heinous offense should not be questioned.
Agree.
Yes,
Is it a serious?
and heinous, we understood, it's a kind of very, very serious. And serious offense, it is not defined everywhere, anywhere in Supreme Court. It was illustrative that something like dacoity, rape, and seriousness cannot be judged by the punishment. Seriousness can be where its consequential effect to the society at large. And here, 354, if we agree to the charge frame, but charge can be altered at any stage of the trial. That is one point. And if we take this is a, because at the time of the incident, victim girl was first semester BA student. Year 20 years of about 20 years.
So
She spent whole night in the jungle out of that incident. And statement of the petitioner number 1, Your Lordship may kindly peruse the statement. May I take? See, once he fled away from the classes of the accused, he never bothered to search her.
see, okay.
And the whole night, as per the
This
report.
this is an application by the, joint application by the accused and the victim. And the victim is petition number 1.
Oh, yes, oh, sorry.
Ah,
Petitioner number 1, yes. Petitioner number 2 is accused.
accused.
Yes, yes.
And there's a compromise did. Unless you show that, according to you, if the compromise has been entered into, by forcing you or under duress.
May I take your Lordship to FIR, page 16 of,
After the FIR only, this has been, they have
Yes,
entered the agreement.
but what it's written in the note, in the last para,
Ah,
in the note, it is written, delaying 2 days delay. It was, incident was happening on intervening night of 12th and 13th. FIR was closed on 15th August.
sir, why you are jumping here and there,
No,
one by one?
yes.
What points you would like to make?
I want to point out that delaying of lodging an affair. No. Her justifications, victim justifications, is due to fear of him that he was threatening me. Don't disclose the same to any person. But later I realized, if I am forgiving him today, it is more dangerous for other girls/women. I am lodging this affair for interest of women so that the same would not be happen with them. And Your Lordship, interestingly, when the matter come up for trial, for CC, only just few days before this agreement was entered. Not
But then,
intention.
this is not the accused alone. This petition is by the joint.
Yes, it is there.
Petition number 1 is the victim.
Actually,
Petitioner number 2 is the accused.
actually, I'm
On the
not.
basis of the agreement,
I'm not.
how do we deal with it?
No, I am not against the validity of the agreement. But
Suppose if you dismiss, trial goes on. If it is not proved
yes,
as held by the Supreme Court, will it not be a futile?
it's
If cannot be proved,
the trial court will be the better place to judge whether this trial has to be end or And in what way, affirmative or negative?
482 is enunciated.
It
by the
is
Honorable
for in
Supreme Court.
ends of
Supreme Court,
justice.
Just listen. This court can, while exercising the power under 482, that issue can be considered. That allowing the trial to go on, whether it will be futile or the chances of conviction are bleak or not.
Yes, it's entirely a discretion of this honorable court and an
Not discretion.
inherent
Basis of
power. So I leave it to this court
No,
to
no,
pass any appropriate order.
I'm hearing you. So.
Your Lordship, yes, punishment is maximum punishment in this case is of 366 IPC, 10 years. And rest other is 3 years and 5 years,
Is it a-
3 years and 5 years.
Is it a heinous crime?
No, it comes under the serious offense.
What is the definition of serious?
That's what I'm pointing before this court. There is no any definition of seriousness.
Who
It,
says?
it has to be, it has to be assessed from the nature of the offense.
So according to why this should be also under the category of serious offense?
Because it's about the modesty of the woman. And it's about the one young student.
Then if the victim comes
I just,
forward, if victim comes forward, we have settled the matter, we don't want to have move on life, then in that case,
Then
had it been a accused alone, challenging or praying for quashing the criminal proceedings,
If-
if there are no ingredients, whatever, no
If-
prima facie case, then your submission is absolutely correct.
if
But
I-
there is a situation where the victim came forward. Not only that, she is the petitioner number one.
yes,
And
Your Lordship.
after entered into agreement,
Your Lordship,
and
May I-
the 354A has been dropped or altered. by
Yes,
the
it-
trial court while
yeah,
framing the
it can be
charges.
said, it was altered.
Altered. So,
Your Lordship,
anything else?
yes, may I remind this court that Narendra Singh and Lakshmi Narayan case entirely founded on the concept of compromise agreement
Please don't
No,
remind this.
no,
court. Remind yourself and place your.
307 IPC. It is an attempt to murder, not a murder. At 307 is attempt to murder. Here there's a molestation, attempt to rape.
Hold your business.
Yes, no,
Just wait. Remind yourself, Mr. Counsel, the next public prosecutor, remind yourself and about the decision of the Supreme Court, Honorable Supreme Court, and make submissions. You don't have to remind this court.
no. If there's
This court is-
attempt, seriousness can be
This
judged,
court- this
just
court-
assessed
this
from,
court is conscious,
the seriousness can be assessed from the nature of an offense.
but you may make a submission that don't try to remind this court.
Now,
First, you remind yourself.
what I try to point out is that attempt is almost act done. Almost.
Why not concerned? What almost?
I mean-
Either it should be attempt or it's not to be attempt.
Yes, Your Lordship.
What do you mean by almost? Therefore, request you to remind
If
yourself.
succeed, then it is offense.
Please
uh,
remind yourself, not to this court. Sir,
Offense.
you are making a submission, jumping from one place to another, without there being any conclusion.
I'm, my
we-
humble submission is
we-
only to,
Respect we appreciate your standing in the bar. You will be a learned, additional public educator. You have some conclusion while making a submission. I'm not able to get anything else from you. Seriously. Sincerely, I'm saying. So what is your grounds? Let me take down. What is your submission?
Submission only is that this falls under the category of seriousness of
Falls under the
serious offense.
category
Serious offense.
of serious offense. Why? Is serious offense then? Why this falls under serious offense?
There's a section involved is 366.
Is section involved is 366 and
354,
354,
342,
342,
506.
506.
Criminal intimidations of dire consequences. Part 2. So, serious, as per the Honorable
Next,
Apex Court,
next.
next, your ships, they have entered into mutual relationships, mutual settlements. I have no objection regarding that.
Entered mutual settlement.
But on the ground of seriousness of offense,
Which
I submit,
you don't have.
humbly submit for
any-
dismissal of these petitions.
Huh?
On the ground of seriousness of offense, I humbly submit before this court for the dismissal of the petitions.
Then tell me why this
164 is
366 and 354 and 34506 falls under the category of serious offense. Can you elaborate?
yes, 366 is taking away of without consent.
According to you, it has been established.
According to record available before this court.
No, the materials available on record, according to it has been established.
No, not established, but prima facie it shows. Because this is not a trial court, so from the record, this
This has any documents from the record that is prima facie it shows
yes, prima facie it shows.
where, from which documents,
From the statement of the victim,
whatever. Either victim or whatever. I just wanted to know. So as any documents from the record which you are holding.
FIR, from FIR 161. And 164 is also there.
See, it's a foregone conclusion. Thereafter, things moved in. There is an agreement between and the settlement between the parties. On that context, you argue
Yes, regarding
why we should not-
regarding mutual settlement, I don't have any objections.
Huh?
Regarding mutual settlement, I have no any objections.
This court wants that you to make a submission on the settlement in such a situation.
But in spite of settlement,
Say, you have said it's a. false
this
under the-
honorable court
Just
can
wait.
dismiss also.
Please just wait. You say these sections falls under the category of seriousness. Then let us assume it falls under seriousness. So what would be the value of the compromise?
Because private office affecting private person and to the society at large
No,
is
you-
two different things.
You don't say that. You say, you may argue, since the offense falls under the category of serious offense, the compromise or settlement has got no meaning. You cannot, on the basis of, since the offense is serious, so it doesn't matter whether compromise, no compromise. That should have been your argument.
Yes, but I'm not.
Are you arguing or are you
No, no, no.
submitting
I'm
that?
not.
You are not on that.
Yes, I'm not against this settlement.
So I'll record that. Though the offense falls under serious, the category of serious offense. However, but the parties can enter into a settlement for consideration of quashing under section 482. That is your submission. Is it?
Yes, it's up to parties whether they will enter into settlement or not. but I cannot, I'm not submitting that they can, but I'm submitting that it's up to them. And it's up to the court, noble court,
Whether the court can consider that settlement.
yes, or
After,
for
after,
allowing,
after concluding that these categories of the offense falls under the, category of serious.
yes, exactly, your lordship.
Can that be considered?
No, it's a inherent power, under inherent power, it's a discretion of the court.
Either I'm not able to understand you, or you. I'm not making you understand.
I'm not arguing against the agreement, mutual agreement. Yes, they have entered, it's a part of the court. And under 482 CRPC, this court can allow to quest, this court can quest the proceeding.
We'll quash it.
It's, that's why I'm submitting, your lordship may pass on the appropriate order.
We'll record that, the London additional PP has submitted that this court can quash the proceedings on the basis of the compromise, though it falls under the category of seriousness of the offense. That I'll record, all right?
Yes, after invoking,
This is not my discretion, your submission will be recorded.
no, it's up to your lordship whether
Not
to.
up to me. We expect,
Now, my humble submission is on for the rejection, dismissal of these petitions on the serious ground of seriousness, affecting societal.
take down. Anything
Oh,
else?
no.
Anything
That's all.
else?
That's all. That's all.
You have not pointed out anything from the record, what is in your support.
Yes, there
I've
is.
given you the record. It's
Yes,
because-
it even victim girls approach to the wife of the.
Any judgment? Any judgment?
At this stage, no any judgment. Yes,
Heard Mr. B. Jamuran, counsel for the petitioners, and also heard Mr. G. Tado, learned counsel for the learned additional public prosecutor. Anything else?
That's all, yes.
Because I've heard you for more than around 25 minutes. By filing this application under section 482 of CRPC, 1974, the petitioner have jointly prayed for washing of the criminal proceedings arising out of Itanagar moment BS case number 45 of 2019. Corresponding to, not corresponding to, what is the GR case?
Your case has not been given, but your
Huh?
lordship, it has been session PS case number since the session, it's in before the session code is session case number 49 of 2022.
Huh?
Session case number 49 of 2022.
Okay. Arising out of so and so, huh? In sessions case number 49,
Yes, that's it.
49,
49 of 22.
where do you find it?
Lordship, I've given in case 39, that's annexure 3.
49 of the under section 366, 354, 342, 506 IPC. Pending before the
District and session judge.
session
UPR.
UPR. On the basis of the settlement entered into between the petitioner and the respondent, petitions. Petition number 1 and petition number 2. Take your seat. Please take your seat. Aram sir. FIR. Page 16, FIR.
Yes, page 16.
Next paragraph. The text in a prison matter started with the filing on a FIR by petitioner number 1 against the petitioner number 2 on 15/8/2029 before the officer in charge police station, Naharland. Alleging inter alia that the petitioner number 2, on the pretext of dropping her to the dropping her back to a rented house after having dinner at the house of petitioner number 2, and she happened to be the friend of the younger sister of petitioner number 2, has molested her by taking to a different location instead of the rented house of the petition number 1. The petition number 1 further alleged that she was forcefully taken away. An attempt has been made to force her to agree to the proposal for marriage wedding. Proposal for marriage wedding, petition number 2. Thereafter, the petition number 1 further alleged that after locking the car door from his side, he started physically molesting the petition number 1 inside the car by taking her to undisclosed place. With a threat of dire consequences if the petitioner number 1 doesn't listen to the words of petitioner number 2. The next paragraph. After the receipt of the FIR, the police forwarded the FIR to the women police station in Canada. And accordingly, Itano WPS case number 45 of 2019 under section 354. A within bracket A, capital A, within bracket 1, bracket close, within bracket Roman 2, small Roman 2, bracket close. 362, 342, 506, it was registered. After completion of the investigation, charge sheet was filed. When the charge sheet was filed?
On 31 of 2020. Right, that is page 21 also.
Filed on?
That is on 31 of 2020. by a charge-
3001, 3001, 2020, huh?
Yes, Lord.
2020.
Yes, Lord.
Thereafter, the court below has framed the charges against the petition number 2. Huh?
Yes, Lord.
On when it was framed?
On 24/1 of 2023, that is page 39.
24/1/2023. That's all.
Yes, Lord.
No further.
No further.
proceedings. Then what is your submission on the basis of the compromise?
Yes, Lordship. And since Lordship,
Just say, it's okay. Next para. Mr. These are my counsel, but the petitioner submits that. The petitioner number 1 is the close friend of the younger sister of the petitioner number 2. There arose a misunderstanding between the petitioners after the parties have taken a dinner at the house of the petitioner number 2. The petitioners are, they are not close relatives.
they are from the same area, Lordship.
They are from the same area and having a good relationship. As a family friend, we get other. Having realized that the affair was lost in certain differences. The petitioner number 1 and the petitioner number 2 voluntarily entered into a deed of settlement. Is supported by the close relatives and the family members of the petitioners. The deed of amicable settlement was entered on 12/6/2022. Without there being any question whatsoever. the petitioners have also decided to move on their respective life. And share the cordial relationship. Is there from the same society and they're from the same area where the families and friends are having a cordial relationship among themselves. Therefore, first Lord, washing of the criminal proceedings in Sessions case number 59. Criminal proceedings of Sessions case number 59 of 2023. Pending before the learned something from UPI. Should I record this judgment? Pardon also. Should I record this? I mean, your judgment, not necessary also. Huh?
Not necessary, since Dhyan Singh and Lakshmi Narayan take covers of all the matters.
Mr. Please, relying on the decision of the honorable. Decision of the various faculties as well as honorable Supreme Court. And it's that in view of the settlement. Submits that. Since the offenses against the petition number 2 is of not of serious or heinous in nature. Subsequent compromise public settlement between the petition number 1 and 2. The proceedings maybe as the same may end up in same the Twitter. Which will be the wastage of the precious judicial time of court. Next paragraph. Mr. G. Tadar, learned counsel. Well, strongly refuting the submission of the learned counsel for the petitioner. Submits that. Submits that. The offenses charged against the petition number 1, number 2 is heinous and serious in nature, for which the proceedings cannot be easily washed by exercising inherent power under section 482 of CRPC, 1973. While referring to the FIR, referring to the contents of the FIR as well as the statement recorded under section 161. Yes, CRPC.
164.
164, 161,
164.
164.
Subsection 5.
No, you have not shown me. 161 and 161, 164.
It is there.
Mr. The learned counsel addition for the president. Submits that it prima facie established the guilt of the petition number 2. Therefore, let this court may allow the trial to proceed instead of quashing the proceedings. Next item. I have considered the submissions of the learned counsel of the parties and carefully and carefully scrutinize the materials available on record. Next paragraph. Is that in the case of the, no, it is noticed that the contents of the FIR appears the contents of the FIR appears pointing towards the guilt of the petition number 2. When on so yes, you did it, but it is seen that, no doubt on reading of the FIR, contents of the FIR, it appears to have pointed towards the guilt of the petition number 2. That the petition number 2 had taken the petition number 1 to drop off back to the rented house of the petition number 1. On the as per the version of the petition number 1, the petition number 2 has taken her to the undisclosed place with a proposal of marriage. An attempt had been made to physically and sexual assault victim. That is petition number 1. Normally, once the charges are framed, no, before that. As per the statement recorded on 161 CRPC, it has had a consistency with the version of is reflected in the FIR. It is also seen that while framing the charge, the trial court has dropped the charges under section 354A. And the while primary charge under section 366 and 354, 352, 506 IPC. The trial court has dropped the charges under section 354A. The petitioner number 1 and the petitioner number 2. Next para. Have settled the agreement, settle the matter so as to move online. And to have a cordial relationship amongst the family members as they are from the same society and the same place. The compromise and settlement appears to be made voluntarily by the parties. Just in the case of so-and-so, state of Madhya Pradesh versus Lakshmi Narayan. Huh? You remember that? Para 15, and SP Gupta, I mean, Kapil Gupta. Right. Then after that, huh? This court is not oblivious of the judgment of the law, and not oblivious of the law enunciated by the Honorable Supreme Court. Insofar as the offenses which falls under category of heinous and serious offenses, the court should not quash the proceedings by invoking the power, inherent power under section 482 of CRPC, 1970. In the present case, in the consideration of the materials, this court is of the view that the charges framed against the petitioner number 2 is sort of also under the category of heinous or serious offenses. Moreover, the parties for the better future on relationship have entered into a settlement without there being any settlement voluntarily, and one without any forcible act from any angle, from any other angle. In the interest of justice, is the proceedings, the continuation of proceedings, in the consent view of this court, will end up nothing but an exercise in futility. Next then. In view of the above. And law enunciated by the Honorable Appeals Court. This court is considered the present case being case number, present case being Sessions case number 49 of 2020 under section so and so arising out of PS Itanagar Women PS case number 45 of 2020 pending before the Sessions Court. Deserve its quashment by invoking the inherent power under section 482 of CRPC 1970. Accordingly, consequently, next matter, the proceedings of the criminal proceedings of Sessions case number 49 of 2020, 49 of 2020.
Section 49 of 2020.
2020.
2022.
2022.
22.
Arising out of Eternal Woman PS case number 45 of 2020.
29.
Under section so and so. Pending before this, London Sessions Court UPI is hereby quashed. Next paragraph. Accordingly, the criminal petition stands allowed and disposed of. Right.
Highly honored.
Bibliography. Credit color
Interim benefit granted, madam, on 7/8/2023.
Yes.
We are supposed to produce updated CD, but due to some arrangement lordship, we have got this deputy message from OC in charge that the POXO case may be handled by the DSP rank.
NDPS
Yes,
under section
under section 18C,
oblique 25.
yes, oblique 25. So, my lord,
What is there?
Your lordship,
Is there any material?
yeah, I would like to make a fair submission, your lordship. There are three, your lordship, accused who have been arrested, actually involved. Main accused, he was the person who purchases from a lady. That lady has been arrested, your lordship. And from the lady statement, your lordship, the present applicant and one more person is there. Her statement is exculpatory in nature against them because they were just outside and they were outside the place where the contraband substance was taken by one main accused. They were outside, and from their statement, your lordship, they were not have the conscious possession. They were not have even constructive possession because the vehicle in question in the incident was hired from the present applicant, your lordship, and he has engaged one driver since he was not expert in driving, and three of them went to the place, your lordship, where in main accused, who is not before this court, he went there to purchase this contraband substance from that lady, and he has taken it in a polythene, covered polythene, and from there he came to the car, and from there they went, and in the meantime he received a call, the main accused, and then he has thrown that polythene, black polythene containing contraband substance to the in the roadside, which was later recovered by on the cooperation of the one of the person involved in the offense, but that person was not been taken into custody, Your Lordship. That is the case, Your Lordship.
So he's not involved.
Possession is not.
His only involvement is he has given his car for hire.
Car. But he was accompanying the main accused also, Your Lordship. He was also there in the car. But regarding the transaction, Your Lordship may kindly come to the only one statement I will read out, Your Lordship. Your Lordship may kindly consider the statement of the Your Lordship lady, page number 28, Your Lordship. Your Lordship may kindly peruse the same.
Yes.
Your Lordship, I don't have the copy. That is your only copy, Your Lordship. And Your Lordship may kindly come
What's
to
the name of the accused here?
Ting Chai Apesam.
Huh?
Ting Chai Apesam, Your Lordship, the accused applicant.
Apesam.
And Your Lordship, page 40 is the statement of the main accused, Your Lordship, who hired the car. Page 40.
Tingche Apesam.
Apesa, yes.
Tingtam Wangjin.
He's the main accused. Main accused, Your Lordship.
Page 40.
40 is the statement of main accused, Your Lordship. Your Lordship, the
Tingche.
Ting Chai Apesam.
Tingche Apesam.
Yes, Your Lordship. Page number 12, Your Lordship.
But he accompanied the main accused. They were together.
Yes, the three of us were together, no doubt, Your Lordship.
Yeah.
My lord,
No bail.
my only fault was, yes, my car was being hired by the,
But you have, when your car was hired, why you had to go along with them?
my lord, that car, since I was not expert in
You were
driving.
traveling together
Yes, my lord.
and your friend has clearly made a statement. Where and how they obtained the opium and then where they have concealed in, where they have stopped. Three of you are
But my
together.
lord, I have no idea about the transaction. Yes,
What is it, why, if your car was hired, why you need to accompany?
my lord, I was not expert in driving, so I hired one driver also. So that, because since the accused person here are well acquainted to me, already acquainted
Are
to
you,
me
are
since
you,
from,
are you a conductor of your car?
no, my lord, this car is only medium for my livelihood, my lord.
Sorry,
My lord, my only involvement, my only,
your only involvement is with the main accused.
yes, but then my lord, nothing, if section 18C and the section 25, in order to attach both the section,
Hmm.
there has to be some, my lord, material that I have the knowledge of the contraband. My lord, session court, learned court below has rejected my bail application only on the ground that I have seen the person taking that this contraband from one lady, that in a polythene. I have no idea what was there in the polythene,
So
my
you
lord.
will record it differently, whatever is in the case diary.
And my lord, in this matter, my lord, kindly consider the duration of my stay also. My lord, I was not even, I led the police authority to the recovery of the possession. The contraband was not recovered
See,
from my person
this-
also.
This menace of
Yes.
drugs,
Yes, I
not
understand. my lord.
necessarily everyone should, it's a chain.
My lord, I am neither addict nor a user also.
You tell us why you have accompanied the main accused.
My lord, since my car was being hired, so since I was not so expert in driving the car, so I hired one. I was asked, I was told to, I will get a payment of rupees 5,500. Then I hired that person driver to drive the car. So I will give him 500 rupees. So this way I went there and I was told that we will go there and we'll come back. That's the only incident, my lord.
Where is his statement?
Your Lordship, whose
His statement.
his statement is Your Lordship, applicant, in
Applicant.
page number 12, Your Lordship.
12.
Yes, Your Lordship.
Just wait. this bag was recovered. After you leading the police.
No, my lord.
Yes,
My lord, what happened? While we were coming back from the Khonsa.
you had. On your leading only this bag was recovered, where it was hidden by your friend.
Yes, what happened, my lord? The prime accused has thrown
And
thrown
there's
away.
nothing to show that under what circumstances you have not inquired about the hiding of the bag.
My lord, because
If
I
you are
was,
conscious enough, if you are innocent enough that somebody is hiding a bag while traveling together. On the arrest of, on the information of the police, you led them to recovery of the bag.
my lord, that was not the case.
You had
that-
the knowledge.
No, my lord, I had knowledge because this FIR, if we read the FIR, this was already on specific in.
Your lordship, subject to the correction, your lordship, in page 16, it is statement of driver is there. Perhaps your lordship, driver lead, your lordship, if I am not wrong here. There are page 16 is the statement of the driver, your lordship.
Why not?
Kindly peruse, your lordship.
The person who my driver has not been, is not in the custody, my lord. I was in the vehicle, but then
But he also said, I have agreed to show this photo of the, should be registered and if required, accordingly led OC so and so
Since
to the
it-
spot and recover the bag,
yes,
plastic polythene.
yes,
my lord.
it
what
is
I-
driver, your lordship.
my lord,
And
what-
for that
Not
reason,
the
he,
driver.
My lord, what I am submitting is, my lord, this, if we go by
Driver
the,
may also accompany them because they were,
driver was not arrested, your lordship.
huh?
Here in driver is not arrested yet, your lordship, in this case.
But here, the statement, he had led the OC another person to
my lord,
get it recovered.
my lord, in this case, my lord, since.
You
in
may have
fact,
a good case for trial,
my lord, my
in the
submission,
trial,
my submission, my lord, maybe,
wait for some time.
Yes.
How long you have been?
my lord, it's almost 1 month, 29 days, my lord. So my lord,
180 days.
my-
No, your lordship,
60 days,
60 days, your
60
lordship.
days.
With that, trial will operate only in these sections under section 37, your lordship. Yes, it's this, here it will govern by CRPC only, your lordship.
My lord, if we go by the section, my lord, section, the attraction of this section is particular.
No,
transportation,
not
my
60 years, the 60 days not over,
No.
only one.
Transportation of the contraband, but then, my lord, if I, again, section 25 says, my lord, knowingly permit, my lord, I was not aware of, I was being hired by the person, that person, the prime accused. Now, how do I know that what he is purchasing or what he is collecting from someone? My lord, it was not my business to ask him.
Why would led the police and the other officers to,
My lord, coming to that, my lord. My lord, if we read the FIR, it in the first line says specific input was there. Now, at Naka point, what happened, my lord? On the specific input, the Naka was set up. Now, when police was there in the Naka point, what the prime accused did was, he threw something out from the window of the car.
you have,
So-
you have not said so.
My
That
lord,
is, that is your improved version.
no, no, my lord,
We'll go by your statement here. 161.
the prime accused person threw something out of my car, but then,
That is your improved version, I said.
but my lord,
You
still,
said something different here.
my lord, but this is
You
still
know that
nothing.
the main accused, whatever your colleague has kept somewhere there. And he said, if need be, I will let it. And accordingly, he led the OC, I mean, police and other officers and got it recovered.
My lord, all the accused, all the main prime accused and the main drug dealer, the dealer lady has already been arrested. Now, keeping me in the custody will not serve any purpose, my lord. One, because the section which,
It's a whole racket.
my lord,
This is the reason.
but then, my lord, in my
Huh?
case,
Huh?
my lord, I
In
am,
that case, next week, or else I'll dismiss. Next week. You return to the city. next week,
Okay.
Or else I'll dismiss right now. Because of the materials
yes,
of your own statement. This code is not required.
all right,
Next week,
all right.
on the prayer of Mr. T. Omo, London Council to the applicant, list this matter after a week. Monday,
Okay, Your Lordship.
All right.
Monday after a week. Try your luck.
On fifth, Your Lordship.
On fifth.
Oh,
The London edition.
Port only. On port.
It's a scan copy.
Yes, Your Lordship.
Return it.
Yes, Your
Or
Lordship.
do you return it?
No, Your
Even
Lordship.
if it's
So it can, Your Lordship, usually done.
I have indicated you. Have some more research.
Well, Lord,
Yes.
before I proceed, Lord, I beg to start with one legal phraseology relating to this case, Lord. Human dignity is a dear value of our constitution. Thus, dignity is a paramount tendency to the personal liberty and human happiness. If this constitutional mandate is violated, my lord, then may I?
Yes. sir.
The dear value of our constitution. Thus, human dignity is paramount tendency to the personal liberty and human happiness, my lord. If this constitutional mandate is violated by the investigating officer while conducting the investigation, this honorable court is duty bound to interfere with such kind of investigations. my lord. Now, my lord, I take to the FIR. In this case, my lord,
It's a regular bail,
irregular bail.
section, offense,
Offense is 326.
427.
427. And my lord, I will demonstrate on merit.
Yes.
Even I will not rely on the case diary.
You
and
have the
this-
case diary.
And this 326 will not attract in this case. my lord. 326 will not come into from the FIR itself.
Yes.
My lord, having said so, my lord, this is the offshoot of the striking down of section 497 of the Constitution of India by the Apex Court as an unconstitutional, and thereby making it as a no offense. my lord.
Sir, come to page 12.
Yes. my lord. Now, my lord,
Let us read the FIR.
yes,
Please read.
with due respect and humbly submission, that I have been brutally attacked by Sri so-and-so along with his gang members on 28/2023 at so-and-so resort, Doimuk around 10:45 AM. Further, it is pertinent to mention herein that they were pre-planned to attack me as some years back, Sri so-and-so forcefully making unnecessary allegation that I was having affairs with, my lord will mark this particular line, with so-and-so without any proof. And that is the reason why today they brutally attack me with deadly weapons like iron rod, stones. My lord will also mark this. Iron rod, stones, wooden sticks, and thereafter I was almost unconscious state and found that I got seriously inflicted or injury by the weapon they use, like left side of my lord will mark this, left side of my ears have fully beaten me.
Very serious.
Yes. Beaten off, my lord, kindly see, mark this, beaten off and serious head injury, and thereafter doctor had suggested to CT scan to injure head. Further, my vehicle have been fully damaged by attackers. Therefore, 326, it is written by one Amosa. My lord, kindly, section 326 has to be read conjointly with section 335 of the penal code. My lord, kindly come.
Yes.
326.
IPC. 326.
326, my lord, then I'll take my lord to 335. Voluntarily causing grievous hurt by dangerous weapons or means, whoever except in the case provided for by section 335 voluntarily causes grievous hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which used as a weapon of offense is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years, and shall also liable to be fined. Now, my lord, kindly come to the FIR again for a moment. He has alleged that there was a use of iron rods, deadly weapons and all, but at the end of the FIR, my lord, the complainant himself says, I got seriously inflicted or injury by weapons they use, like left side of my ears have fully beaten off by mouth. None of the ingredient as prescribed in section 326 comes into play. Then my lord will kindly come to 335 for a moment.
No. It means
Because it is his.
he got seriously inflicted of injury by
Correct.
weapons they use, like including beaten his ear.
No, beaten his ear means
He
what?
got in serious
By-
injuries
No. There,
by the weapons used, including bitten your ears. What do we call it? Bitten off.
beaten off. How with that instrument
Actually
somebody
bitten
can beat
a
off?
serious head injury. So that's it.
That's why, my lord. How the air can be beaten
The-
off by a
The
down?
writer of the FIR may not be as good as you,
Grateful, my lord.
and the English.
But equally, my lord, I am not a student of literature, my lord. I'm trying to be a
So,
student of law and
What
trying,
is trying to convey?
yes,
It's an information.
it's an information. It's an-
Conveys the
Yeah.
substance.
Yeah, my lord.
Substance has to be read, not the grammatical mistake. Grammatically, we
No,
cannot read.
no, this is not a grammatical mistake. The literature is
No,
structured
I'm
in
not
such a way.
saying grammatical mistake. Grammatically, we cannot read. The contents and the substance has to be read while
Together,
we're reading the FIR.
there cannot be conjunctive and disjunctive, my lord.
Yes,
No, my lord, kindly come to 335 for a moment. We read together.
yes. Now you tell me,
No, my lord, I'm
you,
coming,
you,
I'm
what
thereafter,
ground you have,
no,
when you have been arrested,
20th, my lord.
20th of
Yes.
this month,
My lord, yes, after this, my lord, I'll. come-
yesterday,
Yes, there,
therefore.
yeah, 20th.
20, okay.
My lord, thereafter, my lord, kindly let us read together.
We'll see if your interrogation may not be required after 10 days. If it is not required, we'll grant him the bail.
It is already on the
It
judicial
appears to
custody,
be a
my lord.
serious one, 307, not 307,
Lordship,
326.
326
326, Lordship,
and
and
427.
427 of the 34.
What is 427?
427 is causing mischief.
Yes. Is there any medical report?
Lordship, yes, Lordship, medical report is also, the statement also been recorded, Lordship.
Hmm?
Statements also been recorded.
You
Of
tell
the-
us. What is the statement?
Lordship,
Just go through and tell us. Even after 10 days
Lordship.
in the custody, judicial custody.
Lordship, actually, Lordship, here in this case, he's not alone. He's some three more
No, there are
accomplices.
two more.
No, three more, Lordship.
Two already has been arrested.
Two already
and
been
police
arrested.
Today also.
Today.
My lord, unfortunately, my lord, that's a statement that I have made.
Hmm.
The police have misused the power of the investigation, my lord.
It's okay, you.
No, I'm,
If you made out that misusing of the power,
yes, my lord.
you may challenge in the appropriate.
No,
remedy. You
my lord,
recourse to the
why-
appropriate
why-
remedy.
No, no, my lord, that
Today, we're for,
bail.
Consideration
On,
of the
that's,
bail.
my lord,
so at this stage,
my lord, I am on the merit
this
of the
court
bail.
would like to know
Yes,
whether the further investigation in such a situation is required or not.
not required.
Lordship, as per Lordship, this case daddy Lordship, there are other two accomplices are there.
How
And
many-
two
how
are
many?
accused and other three, total four.
Ah.
Accused been arrested and other two also been arrested, which is today it came in motion stage for the
Yes,
bail
Yes,
application.
yes, we have issued
And
a.
one
issued a
is still-
notice to PP.
Yes,
Yeah.
and one is still advised Lordship, he's need to be arrested. Lordship, here this medical report is also that serious in nature, that yeah, person one Lordship. And Lordship, this case is very initial stage. And
You are subscribing to his submission that it was on the beaten the ears, not by
Lordship.
the sticks and the other weapons.
Lordship, you had Lordship in the medical, this examination Lordship, this report also Lordship, this air part Lordship, that is located one Lordship, it is human bite and grievous in nature. And other this other injuries there Lordship, this is simple, but the blunt object is might be used.
That-
Lordship.
What about the interrogation part?
And because it's still
Then
initial
that it's-
stage.
that- that it's enough.
Lordship is up to the
There's a
Lordship.
injury,
Lordship.
there's a,
And Lordship, that's the only the part is Lordship, this rest of the accusers Lordship, their statement need to be recorded. Because Lordship, today that the motion state which they have filed for the bail application, their CD may be Lordship called for because their statement yet to be recorded and yet to be produced before the court.
My lord, the victim complainant has been in illicit relationship with the my wife. And then on the date of incident, my lord, my wife says that I have some set of meeting with my relatives. And then he left the home early in the morning. And thereafter I went down to the resort and found them in a compromising situation, my lord. Obviously, in a tribal society, this is not permitted, my lord. Secondly, my lord, the alleged accused person had executed an agreement that in future that he will not repeat that prior to the decision, my lord. Therefore, my lord, I said this is offshoot of the striking down of section 197 or 497 of the Indian Penal Code by the Apex Court.
It's a grievous injury.
No, my lord, that's why. And there was a altercation between them. And then I was almost strangulated, my lord. Then somehow I overpowered and I used my teeth, my lord. There was no one along with me. And my lord, these two other gentlemen, they were applicant, they were called after 6 days and the police has arrested them.
Lordship,
And
as
they
per
have
the
reached, wait, they have reached, my lord, the spot after the incident has occurred. And how citizen can be harassed in this manner? You are detaining somebody in this manner. Well, para 6 and 7 is the statement that I have categorically made because I don't want to read out, my lord. Something very unfortunate, my lord.
As per the record, Lordship, they ordered together, Lordship, and one of the accused that accomplished, Lordship, his vehicle was used, Lordship.
My lord, it is a prima facie case of 335, my lord, not. No weapon, my lord. Nothing. It is absolutely by sudden provocation. And it is a case of sudden provocation. I overpowered him. I beaten also, therefore, the ingredient at the best could be, my lord, section 335 of the Indian Penal Code. Kindly, my lord, allow that.
Who is the name of the accused person? Name of the accused person?
Lungkung Tarek.
Lungkung Tarek.
Yes. my lord. Bail 77, yes. Other two, you take out sequence. It is a logam topic. You write it down the name. That's cool. That's good. Mhm. Right. My lord,
You have admitted.
my lord, kindly come to page 18 for a moment.
18.
Page 18. The victim complainant, appears to be in the port of sins.
18.
18, Lord. I wish not to read it out, my lord. My lord, kindly, custodial interrogation is really not required. It's already been committed to judicial custody.
In fact,
Lordship,
as per this statement,
Lordship.
she has admitted, he has
Yes, Lordship.
admitted.
He's
What
clearly
else-
admitted,
What else
Lordship.
you want? What
Lordship.
else you want from the accused?
Lordship, my humble submission that Lordship, let the other accomplices, Lordship, their statement may be recorded and Lordship, after that, Lordship, may be considered Lordship. Because
lord,
Lordship,
here-
in the meantime, Lordship,
Here is a fundamental
because they have
error
already,
always.
Lordship, they have, they have together in the incident, Lordship. And Lordship,
They have also been arrested.
Two of,
Two
that's
of
why,
them have also been arrested.
that's why,
And there is no
When they were arrested?
on 27, they were arrested. Well, that's why normally when the public prosecutors, when they,
One thing will grant him a bail and the other two will consider next week,
well,
not the same time.
no, well,
Because in view of the fact that the present applicant, the accused, has whatever required to be taken from him, he has already admitted.
Lordship.
Tomorrow it may be different, but once you kind of made a statement admitting the guilt, whatever, then I think further interrogation is not required. Further ground will grant him, but rest other two which has been filed
No,
today.
sir.
Since
Their
they have been,
statement,
they were arrested much later, we'll consider that you call for the case, we'll call for the case there.
Lordship.
Next week will be. Okay.
grateful. This can be considered on Friday.
Huh?
This,
Next
You-
Friday,
this Friday.
next Friday. Friday, I think we have holiday. You are the president of the bar, you must know.
Oh, yes, yes, yes. Well, so, well, on Monday kindly.
Huh?
Rest.
No, Monday will be too early. She will have to.
Don't move only.
Huh?
Don't move only.
Doesn't matter.
Well, kindly.
Next week,
Well,
any other than
well,
Monday.
kindly Tuesday.
When you can.
Tuesday.
Lordship, next week, because there's a, Lordship, this earlier occasion also, Lordship, only the
No,
limited.
anyway, we'll come
Yes,
to that
Lordship.
later. Though we have issued a notice to public prosecutor
Lordship.
because nobody was appearing.
Lordship.
With the intent, I mean, the intention that we'll take up this matter along with this.
Lordship. Next
So
week,
we'll,
Lordship.
we'll dispose of this separately
Yeah.
and then.
Earlier
we'll-
2021.
We'll come later to those two
Okay,
matters.
great.
Mr. Titi Tara Lalit, counsel for the petition. Accused, applicant, not the accused, huh?
No,
The applicant is, who is the applicant?
brother, elder
Okay,
brother.
okay. Had Mr. Titi Tara Lalit, counsel for the applicant
Yeah, we-
and also had MS El Hage, Lalit, counsel for the Lalit, additional public prosecutor for the state of Arunachal Pradesh. Next one. By filing this application under section 439 of CRPC, 1973. The applicant prays for release of Press for release of the accused Sri Langkung Tare. Langkung Tare, who was arrested on 20/08/2023 in connection with the PS case number 46 of 2023 under section 326, 427, 34 IPC. Mr.
Para 6 is very, very interesting.
Next. An FIR was lodged on 20/08/2023 by the informant victim alleging that the accused Sri Langkung Tare along with his along with a group of persons attacked the informant victim, public victim brutally by using deadly weapons like iron rod, stones, wooden sticks. After which the informant found himself seriously inflicted with injuries. Including bitten off his ears, the left side of his ears. Accordingly, FIR was registered by the WPS police station, being 46 of 2023. Under section 326, 427, 34 of IPC, about 1860. Thereafter, the accused, Sri Langkung Tare, was arrested. And since then, the accused in the judicial custody.
Yes. Since 25.
In the judicial custody. Mr. MS. Ilhagi. Mr. Titi Tara, that is counsel for the applicant accused, submits that. Well, not record all your whatever those huge legal submissions. Not very, we'll just say.
Not required, not required.
Submits that. We'll record the simple submissions.
Yes.
Records that since the accused has been, accused was arrested on 28/20/23. That's been nearly 10 days. And the accused has already, the police has recorded his appointment while in the custody. Therefore, the further interrogation of the accused is not, may not be required. Mr. Therefore, the accused may be released on bail. That's all. Next para, Mr. M.S. L. Hage, London Additional Public Prosecutor. While referring to the case diary, which contains the report of the medical, which contains medical report, submits that the injury is grievous in nature. And as reflected in the FIR, the accused has bitten the left ear of the informant. And as per the statement of the accused was recorded under 161 CRPC. The accused has admitted the allegation of admitted the allegations.
Lordship, 326 is affected here, Lord.
Huh? No, it's
Section
okay.
326 is affected here, Lordship.
Therefore, the ingredients of section 326 clearly attracts. Moreover, not moreover, see further submits that there are other accused two of which have been arrested 5 days back. When he was arrested,
Lordship, that delay was, Lordship, because this officer in
I
charge.
was arrested on 20.
these two persons,
These two persons were arrested on 27th.
okay,
Sorry.
the other two persons, the other two accused persons have also have been arrested 3 days back. And there are some more persons which required to be arrested. In view of all this fact situation, the release of the accused person, Sri Lanktek Radhe, may hamper the investigation at this stage. And as such, the bail application may be. And bail application deserve dismissal. I have considered the submission of the learning concept of the parties. Also, carefully peruse the case diary. Let's before discovery. By the learned public prosecutor, learned additional public prosecutor. Next one. Having considered the materials in the case diary, admittedly, although the medical reports reflects the injury to be of grievous in nature. The on consideration of the statement recorded on section 161 of the CRPC by the police. This court is of the view that there may not be a further intervention. And there may not be any requirement of further investigation. A further intervention of the accused person, Sri Lanktek Radhe. Have you considered the statement by the accused Sri Lanktek Radhe? This court is of the view that further intervention may not be required. For which his detention. Is considered. May not be required. Next, in view of that. Okay. Accused sitting. One security of like amount. To the satisfaction of the magistrate, of the concerned magistrate.
No, sir.
Chief magistrate will release now.
CDM Lordship, Chief Judicial Magistrate.
CDM concerned chief judicial magistrate. On the following conditions. You just give those conditions, conditions, with the following conditions. The accused city so and so. Shall not hamper or tamper with the evidence. Right. Expert. The accused shall not make any threat, make any, what do we call it?
Lordship,
He should not give a threat to the informant.
Lordship,
Huh?
Lordship.
What should be that condition?
It should not,
The accused shall not induce or make any threat to the informant. Next one. The accused shall not leave the jurisdiction of the chief judicial magistrate, UPR.
Lordship.
without
And he will be appear
prior
before the,
permission of the learned
appear before the IO whenever called for.
The accused shall appear before the IO as and when he is called for.
Much obliged. Next.
Those two cases.
These two cases is very
We
interesting.
issued notice, we'll add that, there's two cases, you have to change the order, that is item
2020.
2021.
Yes,
We have said issued notice to the PP, huh? Then we said, call for the
cases.
Case diary, Lordship.
case diary. List the matter
1 week.
after a week, you fix the date, after a week, if it's Thursday.
One week will be too much, because these people, these two accused, the fact is like this. The wife of the accused informed them that this has happened in the spot, and thereafter they have rushed down to the spot, And then what had happened? They all along escorted the alleged accused person to
You
the
are-
police station also.
You are the member of the gang. You wait for some time. 1 week,
Lordship.
Well,
Obliged.
obviously she'll not be able to get it. You add that, you change that
Which day?
order, huh?
Tuesday,
Because I have already signed, you have to
Yeah.
change that.
Tuesday,
Same order,
which date?
notice to the public prosecutor, call for the case diary, list the matter after 1 week.
12, Lordship, 12 September,
Huh?
12 September.
No, you decide,
11.
11
11
select.
September. Obliged.
I said, you said 2 weeks will be too,
No, oh, sorry.
too far.
After 1 week.
After 1 week.
Six. It's a Diamond police station.
6.
Lordship, actually, they, Lordship, in the earlier this case also, case diary also, it's come late, Lordship. That's why.
Because it doesn't consist, the case diary doesn't
No, have to,
consist about these two accused.
Lordship.
No,
Lordship,
it's
now,
present case
no,
diary.
present there only one accused statement is there, Lordship.
So you get the case diary for these two.
Lordship, that's why, Lordship,
Sending, this way I was now 10 days will be
6.
there on 6,
7, Lordship then.
whatever. huh?
Lordship.
6.
It's okay.
7,
Make
Lordship.
it 7.
PP is always.
There's a matter of 1 day.
No, Milord, why I'm
You
saying,
have
is-
to.
well, Milord, why I'm saying, is only one thing. Milord. these people, they were called by the wife of the alleged accused person. They, both of them went to the spot.
It's okay, sir. You are saying 6, she's saying 7. Make it 7.
Make it 6.
Make it 7.
Obliged,
6.
Lordship.
6.
7, 7.
Lordship. Lordship, recently we have filed wakalat for the respondent number 3, Lordship here. Lordship, we have to file reply. So we have to take instruction from the respondent, Lordship. So
Okay.
this all
You
three
have filed
respondent,
the wakalat number.
Lordship,
Or all the respondent, also respondent.
all the respondent, Lordship. First, Lordship, we have filed,
3 respondents.
Lordship. First, Lordship,
Your
we have filed,
Ketan Tabang,
Lordship.
Mr. Ketan Tabang, learned counsel for the learned counsel submits that he has an instruction to appear on behalf of the respondent number 1, 2, and 3,
Lordship.
for which you have already filed the wakalat number.
Lordship.
For
For
which-
1 and 2, Lordship, for 1 and 2, we have already filed, Lordship.
Ah,
And so recently we have filed 3 also. Respondent number 3, for
then
respondent number 3.
what do you want then?
Lordship, we have to file reply, Lordship, now.
Okay,
So,
no, change the order. Mr. Ketan Tabang, learned counsel, appearing on behalf of the respondents, all the respondents. Press for 3 weeks time to file
Lordship.
a control affidavit. Full stop. Mr.
T Tarin.
P,
Tarin.
your name is there,
Yes, Your Lordship.
where it is?
On last portion, Your Lordship.
Huh?
Tau Tarin. Tau
Okay.
Tarin.
T Tarin, huh?
Yes, Lordship.
T Tarin, learned counsel for the petitioner has no objection. Raises no objection, list of. The prayer of the learned counsel for the respondents is allowed. List this matter after 3 weeks.
Lordship. Give your blessing. Give your blessing.
List this. What is this IA?
is for condemnation of delay. This, I had already filed wakalat number and reply for respondent number 1. And
Yeah.
for 2, I just received an instruction to appear on her behalf. I will be filing wakalat number on her behalf also. I'll be appearing for respondent number 2 also.
Mr. D.K. David, learned counsel for the petitioner.
Not for
Learned counsel
the respondent. Respond,
for respondent number 1. Huh?
yes,
You have already
yes, I had already filed reply.
respondent 1 submits that he has an instruction to appear on behalf of respondent number 2 also, for which he requests some time to file sometimes to take
File wakalat number.
take steps. List of. Take steps for which he required 3 weeks time.
Anytime.
2 weeks.
2 weeks. 2 weeks.
What I've said? Mr. So-and-so, learned counsel appearing on behalf of respondent number 1, submits that he has an instruction to respondent number 2, for which he required some time to take steps, full stop. The list this matter after 2 weeks, so as to enable the.
Can it
Enable
be up to
Mr. DK Daily
3 weeks?
to take appropriate steps as spread for. List of. 3 weeks, make it 3 weeks, huh?
Give your blessing.
Yes,
Pleading is over in this case, madam. May play matter will state after 1 for in admission.
for admission. Admission. Had Mr. El Permelan, counsel for the petitioner and also.
M Tanga,
M. Tangalan, counsel for the respondents.
1 and 2.
Yes, respondents.
Yes.
List of. it is submitted in the burden. It is submitted with the London Council for the parties that pleadings are completed. List the matter for admission hearing after 2 weeks.
Obviously.
May I, Lordship? I'm sorry for the inconvenience, Lordship. In item number 8, there is a interim mode. Lordship.
Yes.
Item number 8.
Let's continue.
Deeply obliged.
24 and 25. What is this?
My Lordship.
Yes.
My Lordship. Lordship, I fairly submit that, Lordship. If you know the maybe satisfied, Lordship.
Huh?
If you know the notice, that is the Parwana issued by the President AGB, Lordship. Basarla Parada. That may be cost, Lordship. Then, Lordship, today morning, Lordship, I have filed one additional affidavit, Lordship.
This IA is for what?
IA, Lordship, for the vacation of the interim order.
Huh?
Vacation of interim order.
Then,
Lordship, basically they has prepared this writ appeal challenging, Lordship, the jurisdiction, Lordship.
okay.
The land is situated at Regi, Lordship. The respondent number 5 is the resident of Nigam village. For this reason, he has
No, no. He has filed a revision, this petition
yes, Lordship.
challenging the Parwana.
Parwana issued by the President Gamura Welfare Society.
Yes.
Yes,
So you are respondent.
yes, respondent 5.
You were at the instant of you only Parwana was issued.
Yes, Lordship.
Huh?
Yes.
So today you are filing this IA. Are you, what do you want? What is the prayer in the IA?
Lordship, land is situated at the Regi, Lordship. That is not dispute.
No,
They
no,
have,
that's why you are saying that the Parwana issued by the President Gampura
yes, Lordship.
it cannot be allowed.
Not Lordship.
Accepted. So you agree to his prayer.
Yes, Lordship.
So we'll dispose it of.
Dispose it,
Two
Lordship.
line. Huh? We'll dispose it of. Huh?
We need some time to file reply on this IA.
No, no, he is executing your prayer. You have prayed for setting aside the Parwana.
Yes, sir.
He said, though he has filed IA for vacating the interim order passed by this court, but then on merit, he said, he's agreed to your prayer. So,
Yes, Lordship.
we'll not go into the merit.
Yes, Lordship.
Since he is conceding the prayer, we'll dispose it of and consequential process will be taken up
Yes, Lordship.
at the competent authority or government, isn't it?
Lordship, I have already filed a complaint before the HGB Regi village, Lordship.
Huh?
In additional affidavit, Lordship.
So you don't want to pursue this Parwana?
No, Lordship.
Will not, should we mention the date? Let us see. We'll dispose it of. Heard Mr. So-and-so learned counsel for the petitioner. Huh? CRP is by whom? Okay. And also heard Mr. Elbam, learned counsel for the respondent. How many respondent?
5, Lordship. Oh, Lordship.
All the respondents.
3, Lordship.
Huh?
3. I am for 3, Lordship.
Next paragraph. By filing this application, the petitioner, with only one petitioner, na?
Yes, sir.
Petitioner has challenged the Parwana, na?
Parwana dated 1/6/2023.
1/6, is it?
Yes, Lord.
No, this is something else. Let us see.
Third Parwana, Lordship.
Huh?
In my IA, Lordship, page 42.
No, no, we'll go by first petition. Impugn complainant subsequent cable proceeding pending the proceeding shall not be. 1/6, no?
Yes, Lordship, 1/6.
What is it? Dated 1/6/2023, passed by the President,
President, Lordship.
President Gabura Association of Leparada District. Huh?
Gaubura Welfare Society, Lordship.
Gabura Welfare Society. Huh?
Yes, Lordship. GBWS, it is written, Lordship.
Gabura Welfare Society of Leparada District for holding a Keba to adjudicate the dispute between the petitioner and the respondents. On the ground that the president of the Gaubura Welfare Society has no jurisdiction to issue such parwana. Mr. Elbam, learned counsel for the respondents, fairly submits and conceded that the parwana issued by the president Gabura Welfare Society, Leparada District, indeed is beyond jurisdiction. Therefore, same is not sustainable in the eyes of law. Next minute. Having considered the submissions of learned counsel for the parties, and in view of the fact that the President Gabura Welfare Society, Leparada District would not have any jurisdiction issue, any parwana for settlement of the dispute between the parties under the law. The parwana dated 1/6/2023 issued by the President Gabura Welfare Society, Leparada District is hereby set aside and passed. Then what should?
Well, Lordship, I have today morning, I have filed one additional affidavit in IA, Lordship.
Saying what?
Saying, Lordship, on dated 24/8/23, Lordship. I
Hmm.
had filed complaint before the NCB.
No, then
Regular.
that would say,
Okay.
in view of the setting aside of the parwana dated 1/6/2023, the parties may recourse to appropriate remedy as permissible under the law. That's all.
All right.
Okay. No, this has been mentioned. 12 and 13 was already mentioned. Same person. What was it? Non appears on call list after 4 weeks.
On the other hand, the petitioner claims that the land upon which they have allegedly of trespassing and damaging the materials belong to him on the basis by the virtue of the government land allotment. So on this regard, this matter has gone through litigation on the several occasions before the Honorable High Court, also claiming the land by the respondent, and the petitioner has clarified before the High Court also, and the final order in this regard was passed by the Honorable High Court Itanagar Permanent Bench in WPC number 5 of 2019, which is at page number 39. It starts from page number 39, and whereas it is clearly made under 5, the Honorable High Court observed with a direction under from para 5 to 9 clearly makes complete clearance that the petitioner has the right, and if the department wants to prove that their land so get cancelled by the due process to the concerned authority of the land department. So High Court has clearly made out that the petitioner has the process the land allotment, but by virtue of which the very criminal case cannot exist. So so if my lord may allow, I will read from 5 to 9. It's 8 more paragraphs. Or I can directly start from 8.
Prayer is for quashing.
Yes,
Primarily on what ground?
Quashing ground that very effort lodged before the Honorable PS case was considered primarily on the complaint received from the junior engineer PWD division.
Yes.
Without proper being inquired, and which has been charged without being inquired.
It has been charge sheeted.
Yes, charge sheeted and trial is proceeding.
So it's a matter of trial.
Yes, my lord, trial is proceeding, and it is a conviction is of remoteness, and I have been harassed since this matter is of 2015.
Why you are saying that there is a remote chance of conviction?
My lord, it's very simple that I have a I have entered in my lane, duly allotted by the government. So if I am being convicted.
What is the stage of trial?
Evidence.
Wait for some time.
My lord, going,
Is this a case of quashing the proceedings? He's on merit. It's not there's no question of compromise.
Yes.
no, it's not a compromise.
Yes, I
here,
know.
In this case, mainly, title is under dispute.
Huh.
PWD, they probably claimed, land over, well, this was the allegation that,
Section 3 of PDPP.
Yes, three. Government portal was dismantled by this accused and others. And there is a, in LCR, there is a allotment order in the name of one Yabang,
One of the accused.
one of the among them. And their claim is accused. Claim is that there was duly allotted to them.
But it is a government land.
Yes, no.
Why this section 3 PDPP has to be charged?
PDP, there complaint is a J.
Yes.
Even,
Suppose you obtain an allotment order of this building. Will you, I mean, to him only, he claims that land, there is an allotment order in his favor, right? So junior engineer made a complaint. On the, what was the allegation?
allegation dismantling of
Trespass.
Government property.
criminal trespass.
Criminal trespass and including destruction,
Dismantle of the government property.
destruction of government property. So suppose to you, not to you, you have to support the prosecution. Suppose if you claim
Yes, my lord.
wrongly you have been given the allotment of this area.
So get it cancelled by the authority.
Can you say that I've been allotted wrongly or rightly? I'll have to get hold of it. Can you say so? And
After
can you
obtaining
enter-
wrongly, I will.
And can you enter into the premises at the government properties?
No, no, my lord, not at all.
Have some demolition and destruction just because you have been allotted a government.
Not only
allotted.
basis of the allotment, I should do the wrongful act in the premises of other premises which is belong to government or any other private properties. So that is not there. No, that is not the case.
So what is the ground? According to you, you have the allotment order.
My lord, one, it's
They
very
would not have any criminal case against.
yes. My lord, it's very simple. I haven't allotted.
Let us see the FIR. You just hold on.
My lord, as per my charge sheet, as per I received the charge sheet that contains.
Now, what is the FIR?
FIR does not contain.
Huh?
The what?
First, we'll see the FIR. Is there any FIR?
Appear in the LCR, not in the petition. Petition here is charge sheet. Matter is order charge sheet.
From where do you get this charge sheet? I mean, this. You have approached this court also.
Yes, my lord, that is why I'm saying the Honorable High Court has made clear direction in the last order of writ petition number 05
To
2019.
consider and pass a speaking order. Huh?
in the as per para 9, from such point of view, the order of the Deputy Commissioner dated 26/9/2018 is then set aside and matter is remanded back to Deputy Commissioner to do the needful as required by the order dated 15/5/2027.
After this only the FIR was lodged.
No, my lord. FIR was already lodged before. It is FIR is of 2015. And it is being going on till date, and I'm being harassed till now without any.
You show us was there FIR?
The charge sheet which I obtained from the court, the copy of the charge sheet, in that the
What is the
FIR
allegation?
is not contained.
What is the allegation?
Only the police brief packed of the stories, the number date of the charge sheet is reflected. The complaint, body of the complaint letter is not there in the charge sheet.
You show
Yes,
me
I
the-
received from
you
the
show me
court.
the allegation.
My lord, prosecution stories, allegation can gather from prosecution story only. That is in page number 5, page number 25. That, my lord, the 28 will, I think it will be probably, no. Prosecution story is at page number 25. That's it. I have not seen FIR. Only charge sheet and the prosecution story submitted by the police.
I've come across the FIR, written FIR.
Written-
I have written FIR. But now I couldn't find it.
Complaint must be there.
Yes.
Yes, that is
What is
the
the
complaint or written FIR, one complaint or written FIR, if it is there, then it will be made.
Huh?
If complaint or written FIR is there, then it would be more clear.
Sir, you have to be clear first. It is your case.
My lord, I have cleared myself. The High Court,
We would like.
High
to-
Court already
forget
said that
the-
this is
forget the
for the-
High Court. High Court is a writ petition. I just wanted to see the complaint.
Yes, yes.
FIR or complaint? Illegal dismantle and demolishing of government protected PWD cement godown at 21. Yes.
my lord, that is their allegation.
Prima facie, no case is made out for quashing.
My lord,
You proceed, will not direct them to proceed with the trial.
my lord, it is their
If
allegation.
you have the thing, then you'll be acquitted.
I have, in my defense, I have allotment and they have not produced that they are being allotted the
They say-
government land.
They say this allegation is demolishing the government godown, PWD godown.
So they have to show to the police authority or
Therefore, charge sheet has been filed, trial is on. What is
My lord-
the
my lord, if I-
exact stage?
Hold on.
It is prosecution evidence is over. PW evidence is over.
no, it's
What is the stage?
it's on the way. It's not over.
You be on the way. You participate on the way. All right,
My lord,
sir, no case.
my lord, the department has
If you want to- if you
not
want-
proved that
if you-
that the land is belongs.
If you want to try some next week, we'll grant you a time, otherwise we'll dismiss it, no case. Allegation is you have demolished or dismantled the property of the
allegation.
PWD. This is,
I admit that is allegation.
and the
But
charge
I
sheet
think
has
it is
been
not
filed.
true.
You participate in the proceedings, try, get yourself acquitted. It's not a case for, made out for quashing.
My lord, what I feel is that if I'm being wrongly alleged, allegation is wrong. So Lord God,
You face the trial. If the allegation is wrong, you will be free. If you can prove. that you are innocent.
My lord, from the one aspect, it is also a bit, has to be observed, I think, that whether the complainant is the rightful authority to complain, or any complaint can be
No, that-
entertained by the police. That is what the principle of FIR says. FIR should have some principle basis on which the FIR should be entertained or considered, and finally has to be charge sheeted. And blank.
Are you
FIR
challenging the power and authority of filing a charge sheet of the police?
I'm saying that the department has forcefully lodged a complaint without having basis.
It's a matter of trial. Is a false or the true that will be decided in the trial.
Department has been.
Are you saying that the department or the officer of the department cannot lodge an FIR or the complaint?
No, they can.
When some person comes and demolish the property of the.
No, of
department,
course, if it is their property, then of course they can lodge.
investigation taken place, and after completion investigation, charge sheet has been filed. You face the trial, withdraw.
Charge already framed.
You face the trial.
Yes, consideration of charge already.
It has been,
Yes.
prosecution
Charge-
evidence over.
charge, already framed.
A charge has been framed.
Yes, yes. It's,
What is the stage
for evidence?
for PWD?
Yes.
PW,
PWS.
not yet started.
Not yet started.
You have enough time. So,
My lord, what I was feeling that if the false complaint is there and the PWD department has no authority.
but Mr. M. Nibo, when we withdraw, dismiss. There's nothing, no ground for a question.
My lord, then the matter be hard, matter be fixed on next day, next week. So
You
I may
have-
try better.
You have,
I may try to
you
convince
have
my
argued,
lord better.
you have argued 15 minutes.
Here actually,
Do you agree? There is a
PWD
case, has the case been made out for quashing of the proceeding?
No, criminal proceeding has to go on.
Yes.
But necessary party here is Department of PWD, not made party. Because genuineness of allotment, if there is any, it was directed by Honorable this court that it is to be accepted by the.
Without implementing the department, this court is inclined to dismiss the writ petition, I mean the criminal petition.
My lord, the matter may be fixed for the next week. So I may come up with better convincing, because it's my duty, responsibility.
Then why you
to
have
my lord.
mentioned, you have mentioned it, you have to, will impose a cost.
My lord, what simply
You
I
are
came.
the one who have mentioned this method for today,
Yes, I was the person.
will impose a cost.
My lord, what is simply thought as per the fundamental principle laid down by the Supreme Court, the FIR should be contained, certain principal point is there on the basis of, only basis of such point or grounds, the FIR should be lodged. But
Were you-
they have,
Were you given the chance to, before the charge was framed? Have you appeared? Obviously,
yes, in the lower court, you of course appeared. It is after observing and observation and the contest made in before the Honorable High Court in WPC 509. So finally, we opt for quashing of FIR because they themselves have failed to prove that that land belongs to
who
their
said?
department.
High Court said so.
No,
In the
High Court has directed, it is for the department to prove that the land is belong to them. So allotment, if the allotment has to be cancelled, there's a procedure by proving that the land is belongs to department, and any wrongful, or if the allotment is obtained in
So-
wrongful way.
So, sir, it's a matter of trial.
Then my lord, the matter may fix next week, so let me try on the last occasion, as the last opportunity. So let me come up with them convincing materials.
Then why you have fixed this method today?
My lord, I simply come with this,
What is that?
and this is just fundamental rules of FIR.
So according to you,
Passed in
They put-
Bhajanlal case. So it doesn't attract the rules. Yes, from 1 to 7 principle is laid down and it does not come under the principle laid down under this case by the Apex Court. That is why I simply came. So if I need to convince more, then I may be given one more week.
out of these principles laid down, which principle falls in your case?
My lord, in Bhajanlal case, it is says that in order to establish a case, to register a case, there's a certain principle that is 1 to 7. So so it's a very small merit. Whether the allegation made in the information reports of the complaint, even if they are taken at their PS value and accepted in their entity, do not permit pressure to constitute or any offense or make out any case against the accused.
Exactly on the ground, I will dismiss it. On the face of it, that
My lord, their allegation is for the demolition and
on the
trespass
face of the FIR,
Hmm.
there's a guilt towards you. You have demolished, you have dismantled the government property. Building of the godown of the Public Works Department. What else you want?
My lord, the allegation has to be
It has
supported
to
with the-
prove, it's a matter of trial. But the on the face of the FIR or the complaint is discloses.
My lord, what I feel is that FIR should come. to
Your
the-
only ground is that I have an allotment order. That's why I've said, given you an instances. If suppose wrongly you have been given an allotment, which is a common feature in the state. Can be by overlapping, by mistake, by error, can be issued. But the facts remain that the
I have,
area you are claiming it belongs to the PWD, where there exists a building or the structures which is being used as godown of the department.
it is their claim.
Therefore,
Yeah.
when you rely this, a personally, your case, your writ petition, this criminal petition is dismissed with heavy cost. And
Well-
you had mentioned this matter yesterday for listing it out of turn.
No, my lord,
This is a 2023 matter.
my lord, last time the matter was, it was directed to list of the matter 2 weeks and it has been already more than 4 weeks, 4 or 5 weeks. So it is not out of the turn only. It was, the matter was, if it comes, it can be listed.
No, you
after
could
2
have mentioned it immediately after the expiry of 2 weeks, but you have waited for another 3 weeks.
Yes, my lord, that is true. But then I had the privilege of mention that is not out of turn or out of the rotation basis or not tricky things has been played. So my lord, anyway, if my lord is not inclined to
List this matter tomorrow. You think about it
my lord,
on the prayer of Mr.
after 1 week, my lord,
M. Nebo, learned counsel for the petition. List this matter on 31st,
1 week,
31/08/2023.
that one
On
zero.
which date Mr. Nebo will place an appropriate decision whether to withdraw the criminal petition or not. If not, the court will pass an appropriate order dismissing the criminal petition with heavy cost.
Tomorrow, no. Okay, my
You
lord.
think, you
Okay, my lord.
think about tonight? We'll see tomorrow.
Okay, my lord. I'll be. Thanks for giving opportunity for necessary preparation. Now it's my turn. I'll try to convince my lord.
You also prepare. Right.
Yeah. PP also will be more prepared, so matter will be more clear.
I'll share with the records. Have you seen the records?
Yes.
Give
Ma'am,
the
but
record- give the-
High Court order,
Give the records to her, him. High Court's order is annexed in the criminal petition.
there is two petitions, writ petitions,
Huh?
two writ petitions.
Forget
one is-
forget about the others. Writ petition is something else.
No, writ petition is not enclosed. The writ petition order is enclosed.
Hmm.
Writ petition is not enclosed here.
Not the court's file, the records. Records, you give the records only.
Hmm.
These are all the records, not the court's file. No. Not petition. Record is the records.
Yes, two
Your
records,
court records.
yes. And sure.
Both of you fight it out tomorrow.
Okay, my lord.
Yes. Hmm. What is this?
That is your lordship.
Yes,
Your lordship, this is an application, so. Praying for free arrest bail, your lordship. Your lordship, here the informant and the applicant were living together for almost 7 years with consent. And the informant was well aware with the fact that he is already married and has 3 daughters, minor daughters. And even after knowing that if they get married, she will be the second wife, she continued to stay with him. Now, after 7 years, when the applicant made the intention to marry her, she is not willing, and she started getting angry and arguing over small to no reason, little to no reason. And on Lordship 7/7/2023, Lordship, without any reason, the informant has kicked out the applicant out of the rented house where they were living together at Lekhi, throwing all the belongings. And subsequently, Lordship, the applicant had to leave the house. So after 7/7/23, and since 9/7/2023, the informant, along with her sisters, and they are constantly calling the applicant, harassing him and demanding fine and compensation on repeated basis. So
has the case been registered?
not registered, your lordship. Only a complaint was filed.
Yes,
And
but-
that too, your lordship, they have tried every means to secure some benefit, financial or material gains.
What do you say?
When they fail,
Your lordship, call for the status report, your lordship, whether the case will be registered or not, your lordship.
We'll see tomorrow. All right.
tomorrow.
But Mr. So-and-so, learned, Gyatso, saying Gyatso, learned counsel to the petitioner, and also Mr. T. the learned petition public prosecutor. Call for the status of the,
Yeah, status report, your lordship.
this is the report of the case, listed matter on Monday or tomorrow.
It can be tomorrow also, your lordship. Whether status should be in written or your lordship, I can take instruction directly whether from the IO concern, whether OC, that whether the FIR has been registered or not. I can be orally take the. Okay, I will take-
They've filed complaint.
Suppose if it is not registered,
Yes, your lordship.
would that registration of the FIR also
Yes,
can be considered?
Yes, Gurbhat Singh
On the
CBI
basis
cases.
of the apprehension.
Yes, apprehension. Gurbhat Singh CBI, your lordship, is settled. your lordship.
Then we'll see tomorrow.
Okay, your lordship. Okay, then your lordship, then regarding status, not required. Or I will take this status report.
No, you take the
Okay,
instruction.
your lordship.
Let us be sure.
Okay, sure. Of life.